12.
No, cross title also shows it is only 13(1).
Right, Your Lordship. However, the impugned judgment has specifically mentioned about another provision of law.
All right, admit. Call for LCR in so and so. What is the position? This judgment was passed long behind 86.
My Lord, I'm under limitation, Your Lordship. My Lord, this judgment is passed on 16/5/23. 16/5/2023. 16 May 2023.
16(5).
Your Lordship.
Then what is the other judgment? Criminal.
My Lord, that is my 125. The wife had filed a 125 petition.
All right. Child is with you.
I'm sorry, Your Lordship.
Child is with you.
Child till date is with me, Your Lordship.
Children,
Yes.
multiple child.
My Lord, the case, my Lord, as per the facts of the case, the husband alleges that I had an
Only
extra.
one daughter.
Yes, Your Lordship. My Lord, however, the husband out of the wedlock has already married somebody else, has a daughter, which I have also annexed at page 35.
Is it a fact husband has already married in meantime?
Yes, Your Lordship. That is also a finding in the criminal case. And my Lord, the allegation is that I have also married somebody else.
What is your position? Have you married?
My Lord, I have filed a case for rape against me on the promise of marriage. However, the learned court has taken
So
into
you also fell in
Your Lordship.
difficulty, right? All right. Yes, Allah. This case will be noticed above for you. Requisites as undertaken by day after tomorrow. Then this case notice as above one set. As an interim while directing stay of the judgment in CP 205 of 22 annexure 2. This court direct maintenance of custody of the child involved, minor child involved, as on today.
I'm grateful, Your Lordships. My Lord, we want to get ourselves heard, at least not on the ground of adultery. My Lord, my instructions are that we will need to give it a try so that we can at least contest that the adulterous grounds and other things against us.
Very difficult with your experience.
I bow down, my Lord.
Whatever,
My Lord,
it's almost impossible in a civil proceeding.
My Lord,
And you have lost an FIR.
My Lord, my husband had lost an FIR. My
My
Lord, husband କରିଛି ନା ମୁଁ ବି କରିଛି. My Lord, husband କରିଛି. My Lord, ମୁଁ ବି କରିଛି.
ଆପଣଙ୍କର adulterous relationship not against husband, against another person.
Your Lordship.
So ଆପଣ ଯେତେବେଳେ ନିଜେ you are a complainant, you are and that there is a case pending, and you admit that there has been a physical relationship in promise of marriage.
Your Lordship.
Post your marriage.
Your Lordship.
So
and
then,
that marriage has taken place also. Mata Sindhu took place forward.
Why are you pursuing the divorce aspect?
My Lord, I need to take instructions on this. My Lord, because there is no maintenance awarded in the divorce petition.
Problem होची कोन कि आपण आपणकर client ର interest ku जगिबे ना ना एटी stay order नेबे.
नहीं किसी लाभ होबनी.
My Lord,
आपणकर at least तांकर adulterous relationship ପାଇଁ कि problem जो second marriage रो जहा भी problem हेची. तांकर second marriage now ran into rough weather. She alleges that she has been ditched
right.
or whatever way, and there is a criminal proceeding.
Bow down, Your Lordship.
So आपण बर्तन fast marriage रो annulment ପାଇଁ आपणकर व्यस्त होचंती जे सेटा केमति रहू intact. सेटा भाबिया कथा ना.
This case have you disclosed that the husband has married in the meantime?
Mo petition re.
This case re.
Miss case re. My Lord, main petition re अछि, Your Lordship.
Main petition
re अछि और तार से जो criminal appeal CRLMC 125 file करछि सेथरे भी it has a categorical finding because the husband has not challenged.
Most likely after your relationship these things have happened.
My Lord,
the other way around.
My Lord, would be a matter of
relationship development hela pore during your subsistence of marriage. These things have happened.
Quite possible, Your Lordship.
So
quite possible, Your Lordship.
So maybe the process of challenging
fate of the child is doomed. Fate of the child is doomed. Husband has married in the meantime. Wife also went in misery.
मतलब
What
ଆଉ
will
ଗୋଟେ
happen
ଚାଇଲ୍ଡ
to
ବି
this
ତାଙ୍କର
child?
ବେଡଲକ୍ ରୁ ବାହାରିଛି ସେ ହଜବେଣ୍ଡ ଆଉ ଯାହାକୁ ବାହା ହେଇଛି ତାର ବି ଛୁଆ ହେଇଯାଇଛି ବିଫୋର
Oh,
5
Tara Hellevi, he may take care.
your
But
lordship.
your character, let us not discuss much.
Actually, that was the other
Achi,
concern.
Without adjudicating that one of the person against whom the OP3 has filed a complaint, Dilip Naik was an employee or not? That is our dispute. Your lordship may kind of,
where is your objection in such proceedings?
yes, page annexure 4, page 20.
Where have you stated,
Yes.
where have you challenged the locus standi of such person?
Page 7, and page 21, para 7.
Please read.
That the reply Avern made in para 2 to the application, the same is also denied and disputed because the opposite party is neither contractor nor an employer, because opposite party bank is a major bank under the ownership of finance order. Further, more, the connection the applicant is under section 2 of the MA Act is applicable in the terms of employer. CM is not correct as the misconception, because next para, the agreement annually square foot basis he was sweeping cleaning is engaging and is also continuing as such.
But this is, this proceeding, the earlier proceeding is that the proceeding undertaken by authority was on individual aspect
Individual aspect
for only one person.
one person. He works, he is claiming to be treated to be the worker. The lordship may kindly contract agreement executed.
20.
He has mentioned the applicant course of inspection. The worker was engaged by the OP.
So that is a technical ground up. No, are you happy? He must be for central government. No.
The one thing I premal
Kete tanga?
that se ଦେଇଛନ୍ତି 3000 ଟଙ୍କା compensation 42396 ଟଙ୍କା. Page 35 last para.
Individual employee 42,000 was.
Here is lordship may kind annexure 5. The square foot he was engaged as a sweeping cleaner on contract basis. Annexure 5 page 26. Annual contract agreement executed. Then your lordship may kind of glance.
You have gone through the recent observation of Honorable Apex Court. 70% cases by the government side is
No, here they are
abuse
the
of process.
if the employee is working on the contractor, then it is applicable.
Okay, right. Now you are in discharge of the employees, immediate employer responsibility.
Immediate as
Where is the immediate employer challenging this award? You can't challenge.
no immediately bank executive
You are
agreement.
the principal employer or not?
Yes.
Right. So principal employer has challenged an award or not?
No, principal employer challenge this.
Challenge the award. Can he challenge? We have already given a judgment.
No.
He can't challenge.
Here there is no intermediary. There is no intermediary.
It's contractor's liability.
Only same person.
So therefore, no. It's a contractor liability.
No. Contractor is same person, my lord. Page 18. Page 19. Page 18, the wrong name indicated. Page Dilip Kumar Naik. Only one person with whom the contractor is executed.
Claim application.
Page 18, mechanical glance. Page 18.
Page 18, it is at the instance of the establishment.
Starts from annexure 3, page 17. The tabulation at page 18.
No, let issue notice on the question of admission, fixing short returnable date. The refugees has undertaken so and so since Jakteswara
Nayak.
Jateshwar Nayak. The Jateshwar Nayak has already appeared for the Union of India. 2 extra copies be served on Sinai. Notice only to workman OP number OP2. Workman OP number 2.
No, workman is not included.
Workman is not made a party.
because-
তাহলে কি fight করিব এটি
Then
litigation?
I will include in party.
Sorry, them defective lead petition.
I will include in party.
First cure the defect. ସେମାନେ
By
ତାଙ୍କର
next-
complaint ପାଇଲେ
by next week I will include in part.
ଆପଣ କରିବେନି ପକ୍କା.
By next,
List the matter on next Monday. In the meantime, let the petitioner bring the party likely to suffer as a party to the proceeding.
obviously.
For order site on or three, may lordship. A matrimonial dispute, my lord, why highly challenging the quantum, my lord?
Notice was already issued.
Yes,
My lord.
notice issue, there
My
was
lord.
a opposite.
I am appearing
You
with the
appeared
opposite
on-
party. Why?
And
I
there
have
was a
adjourned, my lord.
delay of 72 days, my lord,
Delay of 76 days.
72 days.
No, as per stamp reporting, it is 10 days only.
10 days.
10 days only. You are for appellant.
My lord.
Yes,
What is your name?
S. Salahuddin Khan on behalf of Mr.
Huh?
Salahuddin Khan. Salahuddin Khan on behalf of
Salahuddin
Mr.
আর নাই ତ ପାୱାର ନାହିଁ
On
ଆପଣଙ୍କର
behalf of Mr. Dean.
ଅନ୍ ବିହାଫ୍ ହେଲେ ଆଗରୁ କହିବେନି ସେତକ ଭଦ୍ରାମୀ ବି
Sir.
ନାହିଁ ଆଉ ଆପଣ ଯଦି ଆଉଟସାଇଡ ଦି ପାୱାର ଆପିୟର କରିବେ ତାହେଲେ ଦେନ୍ ୟୁ ମଷ୍ଟ ବ୍ରିଙ୍ଗ ଏ ଅଥରାଇଜେସନ ମେମୋ ସେତକ ମିନିମମ୍ କଟେସି ବି ରହୁନାହିଁ ବାରର
Sorry, my lord. I missed.
ये section 5 only 10 days ଅଛି and a woman has come to High Court. So let it go.
Mentioned 72 days. Yes, mentioned in the, there in his
As per
petition.
our calculation.
At the submission of the respective councils. ତାଙ୍କ ନାଁ ଲେଖିବନି ହେଲା council ଙ୍କ ନାଁ ରଖିକି କରିଦବ. Yes, as per the, this is a matter for condonation delay of 10 days as per stamp reporting. Considering the wife is the appellant and hardly 10 days. Further, there has been reason assigned in coming to this court with 10 days delay. This court is inclined to condone the delay. I stand allowed. Yes, appeal, what is the challenge in
My
appeal?
lord, petition copy be served, my lord. Only
I will be
limitation
served.
petition copy already.
ଓହୋ ଆଡମିଟ ହେଲେ ଦିଆହବ ନା ନାଇଁ ଯଦି ଆଡମିଟ ନହବ କାହିଁକି ଆପଣଙ୍କୁ କପି ଦିଆହବ କିଛି ହଉନାହିଁ ବାହାର ଏତେ ପଛକୁ ଚାଲି ଯାଉଛି
ଖଣ୍ଡେ ପତ୍ର ଖାଲି ଯାଇଛି limitation.
that's right. So now it is it's ripe for taking admission. We are considering if it is admissible or
My
not.
lord.
If it is admissible, we will certainly pass. You have already appeared. Why should notice again go? So please have patience.
Sorry, sorry.
Yes, what have you challenged in the
Here is-
appeal?
Here is my lord, challenging the quantum on that divorce was allowed only 1,50,000 permanent alimony was fixed. Whereas husband doing a milk business,
So you are not agreed by dissolution of marriage.
no, we are not.
You are only on the quantum
Quantum.
aspect. Are you sure in your memorandum of appeal, come to your prayer?
Yes, ma'am. I am
Only enhancing, right? Only enhancing. All right, so therefore it is only on quantum. Have you paid that 1.50?
My lord, I have already paid.
You have already
My
paid. What is your status?
Copy be served, I did not take instruction, my lord.
ଆରେ ଆପଣ ଯେତେବେଳେ ଲିମିଟେସନ ରେ appear କଲେ
ଆଜ୍ଞା।
ଆପଣ ତାକୁ କଣ କରୁଛି ପଚାରି ନାହାନ୍ତି ହଜବେଣ୍ଡ
ନା, no.
ହଜବେଣ୍ଡ କଣ କରୁଛି
husband doing milk business as well as he is
ମିଲ୍କ ବିଜନେସ
Guy-
milk business, doing milk business, having 20 buffaloes and also
Okay, all right.
double crop
In any case,
cultivation.
1.50 is very, and she is making a very reasonable call. All right, all right. Issue notice, the appeal is appeal is brought against the order of the Family Court Kendrapada in Civil Proceeding 707 of 2013, confining its challenge on the aspect of permanent alimony of meager sum of rupees 1,50,000. This court find ground to consider the appeal. Admit. For there is already appearance on behalf of the sole respondent, the husband, through Sri Ashok Kumar SAHOO and his associates. Let one copy of the brief be served on such counsels by way of notice. What is your avocation? Are you employed?
No, no.
Unemployed? Yes, place the matter 3 weeks after date kar deo. You take instruction in the meantime. It's a very reasonable. 5 lakhs magici 5 lakhs allow hi jai paribo.
He has already received the 1.5 lakhs, my lord. She has
1.5 ଆପଣ 1,50,000 କେମିତି ଚଳିବେ କହିଲେ ସୋସାଇଟିରେ ଡାଇଭର୍ସ ନେଇଗଲେ ସେ ଡାଇଭର୍ସ ଚ୍ୟାଲେଞ୍ଜ ବି କରୁନାହାନ୍ତି see minimum sustenance of the wife. On the next date of posting, husband is also directed to bring a draft of at least 2 lakhs. Yes. Come with 2 lakhs. Come with 2 lakhs.
Let it come any day, my lord. Take instruction, my lord.
ଆପଣ instruction ଆମେ direction ଦଉଛୁ
ଟଙ୍କା ଆଜ୍ଞା ସେ
ନାଇଁ ନାଇଁ ଆଉ କେତେ ହବ ଆମେ ଚିନ୍ତା କରିବୁ ଆଉ 2 ଲକ୍ଷ ଟଙ୍କା ଧରିକିରି ଆସନ୍ତୁ you have taken divorce.
She has already been
ଏଠି କଣ
received.
ହେଇଛି କି short meager sum
We'll take instruction, my lord. Any day
and
ଆସିବ ଆଜ୍ଞା ମୁଁ ଟିକେ
too
instruction ନେଇଯାଏ.
difficult on the part of a divorcee to run herself in the present society with a sum of rupees 1,50,000. This court consider. This court, while keeping the permanent alimony aspect for further consideration, direct the husband to appear on the next date with affidavit in terms, affidavit of property in terms of Rajnish versus Neha. Rajnish versus Neha on the next date of posting, date rakha. Also, along with a sum of rupees 2 lakhs by way of draft in the name of wife. Property affidavit ଆଣିବେ, income status ଦେବେ ଏବଂ 2 ଲକ୍ଷ ଟଙ୍କା ଧରିକିରି ଆସିବେ.
ଟଙ୍କାଟା ଆଜ୍ଞା ଟିକେ instruction ନେବି ଟଙ୍କାଟା next date ରେ ଆଜ୍ଞା ମୁଁ କରିବି.
Yes, next.
Item 4.
Please, my lord. Sir, my lord, the petitioner has challenged the award under annexure 12. Where, my lord, in absence of pleading, the labor court came to conclusion that this is a time-bound project and hence you are not, you will not be reinstated in service.
Notice has already been issued.
Pleadings are also complete, my lord.
Pleading complete.
Yes, my lord.
But 21 matter.
Yes, my lord, 2021 matter.
What are you challenging here?
I am challenging the award under annexure 12.
Award by Industrial Tribunal.
Yes, my lord.
Annexure
Labor
12,
court,
Annexure 12 page.
Page 73, my lord, have a glance. That is the operative.
Other, who is for other side? State.
Government.
State is the only party.
My lord, the PO is the party and rest is Fishery and ARD Department, Director Animal Husbandry.
You are representing all. Mr.
Yes,
Panda, you are representing all. Then are you ready?
Except opposite part number 4.
Opposite part number 5, Royal Security Service. CTVO is the opposite part number 4.
The service provider. The service provider.
You are service provider. So you are working through service provider.
Yes. That is
the notice has gone to service provider or not?
That is
Yes,
the scheme.
That is the case.
Yes.
That's right. But whether notice has gone or it's only Three
my lord,
extra
may-
copies to state yes, notice to OP5, order dated 1/11/21. Then what happened on the
the notice
on-
was made sufficient, my lord. My lord, the notice was made sufficient.
Notice was made sufficient, any order to that effect?
My lord, there is a order, justice.
এটি 29/11/21 রে AD return from OP5 after valid service. Expecting. So what is the ultimate hour?
Ultimate hour.
There is clear finding that you are in a project work.
Yes, my lord. My lord, but the fact is that advertisement was issued for the mobile veterinary unit attendant.
Mr. Jena, being a young counsel, you must understand you have to argue the best point.
Ma'am.
Straight away you come to the point what you have shown to the learned court
Yes,
that it is not a project. Advertisement ରୁ କଣ ମିଳିବ? Advertisement ରେ ତ ଆପଣ employment ହେଇନାହାନ୍ତି on the face of it. Advertisement ରେ ସେ service provider କୁ ଡାକିଲେ।
service provider କୋଉଠି mention ହିଁ
ଯଦି ବି
ହେଇନି
ଆପଣ advertisement ରେ କଲେ
ଆଜ୍ଞା।
so what is the ଆପଣ କଣ ଦେଖେଇଥିଲେ lower court ରେ? ତାର finding କଣ?
ଆଜ୍ଞା।
So straight away we
So
can
how it
consider
has
that.
been ignored?
because my lord,
How your claim has been
ଆପଣ
ignored?
ଯଦି ଖାଲି advertisement କହିବେ that it is neither here nor there.
because my lord, section
Because employment under a government has to be a kind of a rule regulation cadre.
my lord,
That is the best point they will argue. You must be ready in your mind.
my lord, guideline ରେ in the guideline
Guideline ରେ ଆପଣ ଯଦି substantive employment ପାଇ ନଥିବେ ତାହେଲେ retracement କେମିତି ହବ?
in the
So,
guide
ଆପଣ ସବୁବେଳେ other side କଣ ଭାବିବେ ସେଟା କହିବେ ସେଟା ବି prepare ହେଇଥିବେ. Court କଣ କହିବେ prepare ହେଇଥିବେ. Still then it will not be adequate. Court will ask you a third question.
my lord, what
So
they,
don't just go. ଯୋଉଟା advertisement ହେଇଥିଲା advertisement ରେ ତ ସେ satisfy ହେଇପାରିଲେନି.
my lord, what they are mentioning is that in the guideline it has been mentioned through service provider, but in our
statement kain? A statement of claim kain?
my lord, we have in flag 10, my lord, we have filed one additional affidavit.
No additional affidavit here.
My lord,
It's an
we have
industrial
already
affidavit.
filed as per the direction of this honorable court. We have
Forget those things. Somebody
Additional affidavit ରେ କଣ ଲଗେଇଛନ୍ତି ସେଗୁଡାକ? Pleading ଲଗେଇଛନ୍ତି ନା କଣ statement ଦେଇଛନ୍ତି?
statement of claim କୋଉଠି ଅଛି ଦେଖାନ୍ତୁ?
Straight away
additional affidavit ରେ, my lord,
Where is your statement of claim? Additional affidavit ରେ did you enclose that?
no, my lord, in additional affidavit we have only enclosed the documents which were
Oh,
marked
they are
as
asking a particular question. Answer if you are prepared.
no, my-
Otherwise, take adjournment.
my lord, the
We
only
can't go on chasing you.
my lord, the
You
only
say there was a certain type of appointment and they have given a different appointment.
yes, my lord.
Then it is to be seen whether you have challenged at that stage or you simply joined.
My lord, we have joined in the
So joined, then therefore there is no challenge to that.
my lord,
That's why the foundation is your statement of claim. And what is the issue framed and how the tribunal has answered or the labor court has answered.
my lord,
You are too young to argue such matters. This is not an easy matter.
my lord, what the only point is they are only stating
So
that
you will not answer to the queries. of
sorry,
the
my
court.
lord. My lord, we have, I
Prepare
will
हुंतु. Prepare हुंतु, then you
my lord, I will file another additional affidavit including
sorry, ଆପଣ ଯାହା pleading ଅଛି, we can't time and again we have been repeating. My lord is repeating.
my lord,
Please don't expand these pleadings. Then it becomes endless, also aimless.
my lord.
Litigation ର ଗୋଟେ aim and ରହିବା କଥା. ଆମେ ଯଦି we go on expanding, ସେ ସେଠୁ କହିବେ ଆମକୁ ଦିଅନ୍ତୁ liberty. ଆମେ file
ହେଇପାରିବନି
କରିବୁ।
ଆଜ୍ଞା, ଏଗୁଡାକ
So
ସବୁ
ସେଥିପାଇଁ
statutory
statutory proceeding ରେ statutory appeal ଆମେ ଯଦି expand କାହିଁ କରାଯାଏନି? There has to be a finality of the adjudication.
You are given opportunity. It's a two-way proceeding.
Yes, my lord.
It's a two-way proceeding.
Right.
So you brought an application before the labor court for industrial adjudication of an issue.
My lord.
And that is, so therefore the question is what was your stand there? And that can be gone into only through the statement of claim you have produced there or the application under section 2A under the new system.
My lord.
You don't bring that.
Then my lord, may keep it to some other day. My lord, I will file that through additional affidavit.
Call first because this acha hame order already hai sir ki open of file section. Is there any order making OP number 5 subsequent?
My lord.
Some court went on giving liberty of bringing additional affidavit, further affidavit. Where is the scope? OP number 5 upare substantive ବୋଲି କୋଉଠି observation ହେଲା କି?
Observation, my lord.
Yes, there is sufficiency of notice on OP number 3. There is also recording in the order dated 10/3/23 on OP number 5 goes unrepresented in spite of sufficiency in service. Counsel for the petitioner is unable to produce the application under section 2A. Yahala, some court has given file additional evidence disclosing document standard. We could have simply called for the LCR. That's all. That's all. Why should we go and now he files 2 documents, 3 documents are suppressed. Why should we go to that extent?
LCR call for Heni.
Nah.
Are you sure?
My lord, LCR, my lord.
No, it is completely defective procedure adopted. Notice na LCR iti kardova katha because these are industrial adjudications. Therefore, LCR should come. Sab khali notice issue hegala. Even though the matter has been admitted, service should complete. There is no calling for LCR as of now. Petitioner in spite of Asi. Dekhela LCR dela.
Scanned copy of LCR in ID case.
Achi. Okay, then if LCR is there, what is the necessity of asking him to file this document? Put LCR achi.
Last
Scan copy of LCR in ID 35. Dear LCR. ଆପଣ ଆଜି ରେଡି ଆର୍ଗୁ କରିବା ପାଇଁ କାହିଁ ଶୁଣନ୍ତୁ ଜମା ମିଠା ମନ୍ତ୍ର ନ ଜାଣିକି ସାପ ଗାତରେ ହାତ ମାରନ୍ତୁ।
No, my lord, may keep it to next week, my lord. I will file additional.
ଆପଣଙ୍କର କେତେଟା ପ୍ରଭୁ ଜେନା କେତେଟା ଆଇଡି କେସ୍ ଥିଲା?
ID case ଏଟା
ସମସ୍ତଙ୍କର ହଜରତ ଖାନ
ହଜରତ ଖାନ
ଏଲସିଆର ନାହିଁ। ଦେଖନ୍ତୁ ହଜାରତରେ ନାହିଁ, ସୁଦାମ ପ୍ରଧାନରେ ଅଛି, ଯୋଉଟା କହୁଛନ୍ତି କୋର୍ଟ ମାଷ୍ଟର, ଯୋଗେଶ ପ୍ରଧାନରେ ଅଛି, ଲକ୍ଷ୍ମୀକାନ୍ତ ଭୋଇରେ ଅଛି, ଶମ୍ଭୁନାଥ ସେଠି ସେଥିରେ ବି ଅଛି। ସୋ ମେ ବି ହଜାରତରେ ସାର୍ ଆଣିବାକୁ ପଡିବ। ହଜାରତ ସାର୍ ପ୍ରଥମଟା ଆଜ୍ଞା ହଜରତ ଖାନ।
In spite of service of notice and so, there is no receipt of the LCR in ID case number.
This is that is
28. 28 of 19.
Yes, my lord, 28 of 2019. ID case number 28 of
or 6/2-19.
No, my lord, ID case number 28 of 2019. That is under challenge.
28 of 2019 from the office of Labor Court Bhubaneswar.
ଆପଣ ବି ଦେଖୁନାହାନ୍ତି ଚିତ୍ତରଞ୍ଜନ ଭୋଇ ଦେଇଛନ୍ତି କୋଉଠି?
Place the matter. Place all these matters 4 weeks after receipt of the LCR in the In the meantime, LCR in the aforesaid case may be obtained. ID case रे बहुत preparation दरकार।
जोटा जहार LCR ता साथ लगे रखो। एटा आपण देजन चित्तरंजन भोई, एटा हजारत नो।
एटा फर्स्ट केस रे आसीबो LCR हला, आरो केस गुडा करे सब LCR अछि। कोर्ट मास्टर जोटा नोट देला बेले ताको ठीक से देखुता, एटा रे LCR नाही। So let us give a noting that LCR is yet to receive. बाकी तଳ केस जेतक अछि सबुतरे लेखा हैछि LCR scan copy of LCR available. Matter to come up again along with all other matters in list and the LCRs there. Yes, item 5.
Item 5.
May I please, Your Lordship? Lordships, in this appeal, Your Lordship, were challenging the order of the learned family judge Hon'Ble, Your Lordship,
Huh?
Yeah, the challenge is to the order of the judgment of learned family judge
No,
Hon'Ble.
no, what are the defects? Is there any major defect? Have you seen the defects?
Lordship, as I
It has
verified,
come in orders, no delay, paid, certified copy of impugned judgment filed. Our defect kona? No, it other defects 9 re not properly indexed. Ago proper index kar diyo.
yes, Lordship.
Counsel for the petitioner is permitted to properly index the brief in order to remove the defect number 9. Properly index the brief. Okay. Yes, who are you?
Lordships, I'm the husband and the opposite party in the lower court. Lord, I'm the husband, my lord.
You are the husband.
Yes, my lord.
Okay, what are you challenging?
Lordship, I've challenged the judgment on 3 counts, my lord. First, the judgment has been
Judgment in a case?
family case for divorce, my lord, divorce and maintenance.
You had gone for divorce?
No, my lord. The wife went for the divorce, my lord.
Nilamadhav Dvivedi pra? Okay, wife
husband.
went for. Seta ago koibe na?
Again,
Wife's application having been allowed or rejected?
allowed, my lord.
Allowed, the husband has come in challenging that.
Yes, my lord.
So wife application has been allowed with a permanent alimony grant also.
Yes, my lord.
15 lakhs. Where is your written statement?
Lordship, that's my ground, my lord. If Lordship peruse the orders of the lower court, I have not given an opportunity to file my written statements, in spite of the fact that the proceeding for the lower court involved disputed question of facts. I was
You
given.
were not provided means, so do you mean to say that notice was not served on you?
Lordship, I appeared. I asked for time before the lower court to provide me some time to file written statement. Lordship, my kindly peruse page 40. I have annexed the orders of the lower court.
14.
40, my lord.
40.
40.
40.
Yes, my lord. The appeal by his lordship, the case was filed on your lordship 10th of August 2022. It was admitted on 19th of August 2022. Lordship, then I appeared on 1st of November 2022. Both the parties appeared on 7th of December, my lord. I was given chance to twice, my lord. 7th of December, then my lord, 23rd of December. On the very next date, 10th of January, lordship, I requested the lower court to provide me some time to file written statement. But the lower court went on saying that, my lordship, may I read?
Yes, go on.
On page 41, the order dated 10th of January 2023, the petitioner present, but the respondent absent. The case reads posted to decree to the side of the at the stage the advocate files appearance for the respondent, praying therein to file written statement on the ground stated therein, peruse the case. At this stage, the petitioner to the application to file written statement is not maintainable, hence stands rejected.
Then you should have come at that stage. Why did you allow the finality of the proceeding?
He should have been, your lordship. I do agree with that. He should have come at this stage only. Even if your lordship peruse the page 37, internal page 25 of the judgment.
Have you taken instruction? What is the interest subsisting now? If the husband ready to take the wife?
Yes, my lord. I have taken.
What was the ground of divorce?
Ground of divorce, your lordship, mental cruelty.
Cruelty by husband?
Yes, my lord.
And his family member?
And no, my lord. The main allegation is substantial allegation is against the husband only. And moreover, your lordship, the wife had stated that she was not aware of my previous marriage.
Both are, oh, there was previous marriage.
Yes, my lord. Divorce as a decree has been finalized. I have paid the permanent alimony in that matter also.
Your marriage?
Lordship, divorce has been filed, decree has been granted. I have paid the
But yes,
permanent alimony in that.
maybe. So therefore, there is no strange in the allegation.
Lordship,
She is justified saying that on suppression you have got into marriage.
but Lordship, I have never suppressed those things, Lordship. That was in the knowledge of the mediator and the sisters of the wife also.
Here, you have no written statement even.
Yes, that's my sole predicament, Lordship. I have not given an opportunity to present my
You have
case.
the case here only. Right, expert your କରିବେ all right, issue notice on the question of admission. Admit କରିବ.
I don't know, once you entered into that matrimony, then got divorced, then now your salary is 1,39,000. How do you get over these findings? Suppose you are giving you an opportunity.
Yes, my lord.
You have to also think about that and advise your client accordingly. Now, yes, you have made out a case for issuance of notice.
Fixing short returnable date.
My prayers,
considering
Lordship, I was never given
the
an opportunity.
appeal involved challenge to appearing to be an expert in judgment and appeal. It is made clear the matter shall be heard and disposed on the next date. 4 weeks after the date, requisite by tomorrow, as undertaken by tomorrow.
Day after tomorrow.
Now,
Chutti hai ji, day after tomorrow.
day after working day. Right, then how the wife is surviving?
Lordship, the wife, as per my instruction, Lordship, the wife is an MBA graduate in HR, and she was doing some job in 2022.
There is no entry maintenance there in the trial court.
No, my lord.
You go on paying something.
Lordship, my first submission in Lordships, I don't want the marriage to be dissolved.
No, you may not be, but after the girl comes to know that you had earlier marriage, you have gone for a divorce. So all these things is very relevant.
If Lordship may kindly pay the annexure 4 series, Your Lordships.
And as appears, she was completely unaware.
Lordship, if Lordship allows me, may I read the annexure 4?
Difference also. You said 48.
Issue notice, as an interim, there shall be stay of the judgment in CP number 61 of 2022, subject to, however, husband depositing a sum of rupees, at least a sum of rupees 7,50,000 in this court within a period of 3 weeks.
Lordship,
You deposit 50% of the amount.
Lordship, may I take instructions regarding that?
3 weeks time.
Lordship, may grant me some extra time, my lord.
Pardon?
He is jobless, my lord.
Jobless.
Your Lordship, I attest the income tax return also.
Maybe jobless. Now go to jail and run.
No, my lord.
Then deposit. You want to take away expertise judgment. She is already in benefit. She may be taking, or this money will be kept lying until again final decision of the family court.
Lordship may grant.
So therefore, there must be some guarantee. See, you are in multiple defaults. One, in the marriage, you did not disclose that you have a pendency of a divorce proceeding.
Lordship, not pending, my lord.
Two, marriage is taking place, maybe the age gap is almost nearing 20 years. So therefore, there is definite second marriage of the husband.
Lordship, by the time. Lordship, tell me.
So listen,
Okay.
listen, how many defaults you have? The stage when you made expertise, you did not come to court. So what is the loss you are now causing to the wife? So cost will be definitely there in restoration of these matters. That Yes.
Lordship, I'm standing for the appellant, husband. Lordship,
Appellant, notice in the limitation was issued.
so limitation of 30 days delay is there.
30 days delay, so it is first time.
Lordship.
Yes, there is 30 days delay in bringing the appeal. There has been also filing of an application for condonation of delay. IA 221 of 23, this for direct issuing notice in the matter of limitation. All requisites as undertaken by day after tomorrow. IA 221 of 23 be listed immediately after service of notice on the wife involved herein. एठी भी एठी decree ହେଇଯାଇଛି or
Sir,
your
Lordship.
has been rejected. All right, देखियो. Husband has come.
Obliged.
Item 7,
My lord, this is for change of nomenclature from MATA to RPFM. It was wrongly typed as MATA.
Okay, this is an application. It is 247 of 23. And this is an application for change of the nomenclature. Okay, this application stand allowed. Registry directed to act accordingly and entering into fresh stamp reporting. List the matter under appropriate assignment.
My lord, one miscase was filed.
Present at the virtual Bhubaneswar.
Yes, wow. What else you are submitting?
My lord, one miscase was also filed in this case. So kindly, my lord, leave the matter next week.
ଆଗ ଆମ assignment ନୁହଁ ଆଉ ବୁଝିପାରୁଛନ୍ତି ଆପଣ ତ RPFM ମାନେ ଆଉ ଗୋଟେ ବେଞ୍ଚ କୁ ଯିବ ତ ଆମେ we to pass some order there.
Vote କରିବେ ନା ଆଉ
କୁହନ୍ତୁ
ମେମୋଟା ଦେବେ
ଆଜ୍ଞା
ହେଇଯିବ ଆପଣ ଯଦି urgency ଅଛି you change the registry.
my lord.
item 8,
May be permitted to submit on behalf of BK Mahapatra Miller.
What is the defect?
Defect, second copy ta दे दीजिए हजूर.
Second copy of appeal memo file करनाहांती
कर दीजिए हजूर.
already filed since
Second copy has been filed.
already filed.
Has been filed Miller.
माइक आगे कौन
Second copy has already been filed Miller.
फाइल କରିଛନ୍ତି ଅଛି ଆପଣଙ୍କ ପାଖରେ brief ଅଛି
copy of document not
note is yes who has come here the wife has come.
Yes Miller.
Okay, wife against
Against the order of restitution of conjugal rights Miller because
husband's application
Husband's
restitution of conjugal right.
yes Miller. And I am challenging that order as because in the first occasion on 4/12/2021 I was
But
directed.
why are you challenging?
Pardon sir?
Why are you challenging?
As because if I will go there,
Is it enforceable?
Lord, the thing
Is
is,
it enforceable? Section 9 order, is it enforceable?
no, not enforceable.
Then
But
why are you challenging these orders?
as because I have specifically given instruction to do this or that, as because that's why I am here. Because once I have complied with the direction of the court, and when I reached the husband, he ill-treated me. For that purpose, I have to run away, and that is annexure 1.
All I take notice.
Actually,
What are you doing? Are you unemployed?
unemployed.
Unemployed. So you are You decide to stay apart.
Yes, because I have been tortured very.
There's no possibility. There's no
yes,
possibility.
no.
Once it is also.
That's why,
attempt is
that's why I
made,
have filed a
One
counterclaim
attempt is
before
already
the
failed.
lower court, my lord.
all right, issue notice कर दे, stay कर दो. There shall be stay of the operation of the interim order. Requisites by day after tomorrow. Defect ignored. Huh?
For addition item 9,
May Lordship kindly peruse your Lordship's order dated 21/7/2020.
Order dated
21/7/2023. Lordship called for a report from the Judge Family Court regarding the
no. Please read from para 4.
paragraph 4 of the impugned order.
Yes, yes. Of the order dated 21/7.
Yes. In course of hearing, Sri
Okay,
Das
mic টা down କରନ୍ତୁ.
Mal. In course of hearing, Sri Das, learned counsel appearing for the husband, makes clear statement that the husband, in terms of the direction for depositing a sum of rupees 2 lakhs as permanent alimony to the wife and rupees 1,50,000 as maintenance and educational expenses of the daughter, apart from going on paying a sum of rupees 3,500 per month for their maintenance. Deposit of rupees 3,50,000 has already been made before the learned judge family court Cuttack. There is no recording of such deposit in the entire order sheet
Call
here.
for a report.
Yes, ma'am.
Now report ଦେଇଛି ସେ. ଆପଣ କିଏ wife କିଏ?
My lord, I am for the wife.
ନଉନାହାନ୍ତି ଟଙ୍କା ତ deposit ହେଇଛି.
I have challenged that order.
You have challenged that order.
Yes,
Then in that event, the amount must be kept in fixed deposit. Why should it lie?
For that reason, your lordship called for a report. For that
That's right.
reason.
All right, now we'll direct the peruse the letter of Judge Family Court Cuttack dated 8/8/2023 appears to have been submitted pursuant to direction of this court dated 21/7/23. Letter disclosed on the husband deposited the sum of rupees 3,50,000 in shape of, my goodness, कौन ये 2009 ରୁ current account ରଖୁଛି? କଣ ହବ ବର୍ତ୍ତମାନ? Mr. Panda, yeah, it appears you are in the Judge Family Court Cuttack. Unfortunately, for wife not taking steps for withdrawing such amount, the amount has been kept in current account for last 14 years. This fact would not have been revealed until unless this court gave a direction to the family court for giving a report by its order dated 21/7/23. In the circumstance, directing the Judge Family Court Cuttack to invest the money under kept in the current account, above money kept in current account of Judge Family Court in at least annual yield fixed deposit in a nationalized bank. Direct the registry to call for explanation from all the family judges involved in the meantime to submit in the event such a heavy amount came to be deposited in its court. What happened to all such persons in at least reporting the High Court for the requiring direction of the High Court for proper investment of the amount in the pendency of the matrimonial appeal 53 of 2009. Report this. Dated 3/3/2010, the matter was admitted. This court, a division bench of this court, while admitting the matter, called for LCR. Unfortunately, the family courts involved in the meantime did not brought to the notice of the deposit aspect to the court also. Okay. LCR देखेला brief रे किसी नहीं এটা জেরক্স কপি অফ LCR অবশ্য সবই ଦେଇଥିବେ ତ original ନାହିଁ and the LCR is received on 17/3/2010. There is unfortunately no such instruction brought to the information brought to the High Court. At least High Court passing some order, keeping in view the appeal was pending here. The condor dismissal. ঠিক আছে ড্রাফটটা আগে কোর্টକୁ ଆସିବ କୋର୍ଟକୁ ଆସିଲା ପରେ ଆଉ ଅର୍ଡର କଲେନି এটা କେତେ ତାରିଖ ଆସିଲା କୋର୍ଟ ଅର୍ଡର କରିଥିଲେ 14/10/2009 let the same be deposited in the court account discussed to and after collection same be discussed ସେତିକି ରହିଗଲା ତାପରେ ସେ ଟେକ୍ ଅଫ୍ କରିବା କଥା ସେ ମ୍ୟାଟର ଆଉ ନାହିଁ ଆଉ ତ ତାପରେ ଟଙ୍କା ଆସିଗଲା
Item 10.
On perusal of the LCR, this court again find there is already order on refusal of the wife to receive the same. and therefore there is a direction to keep the amount in account. This court observed favor of the wife to receive the amount by order dated, seta delo tike dio, seta dio. By order dated. Tell seta dio. Draft kori do. Also 2009. In the same order, it was also directed for release of this amount in favor of Pranati Mishra, the wife, after the collection of the deposited amount from bank. The LCR provided has no further ordership beyond order dated 14/10/2009. मतलब दबो मतलब तो सजा। देखो तो कहते ये
Well,
आदि
that-
जदि केस भी अल्टीमेटली डिसमिस हबो कौन है लाउ किसी डेवलपमेंट हैला की
Well, there is no development because I got instruction that in the meantime, the husband has married and she is having
so
issues.
therefore कौन हबो इथिरे आओ so now it may be a maximum a case of permanent alimony.
That's true.
Permanent alimony we can enhance. Argue on that. Yes, your client has already married in
Yes,
the meantime.
and blessed with a daughter.
Huh?
He has a daughter also.
He has a daughter
In
also.
2011, he married.
Out order number record. The unfortunate case when both sides admit the husband has already married in the meantime. Not only that, the husband is also blessed with a child.
Yeah.
Gote pila, blessed with a child in the meantime. In this circumstance, this court finds there is no possibility of a reunion at this stage. This court appreciates the submission of Sri Panda Learned Counsel, who presently confine on the question of quantum of permanent alimony. Presently, the case needs consideration on the quantum aspect alone. Sri Das, Sarat Das, SK Das Learned Counsel appearing for the husband seeks at least 10 days time to sit with the client and come forward with appropriate offer by the next date. Okay, call the matter 2 weeks re kora 14 din pare working date.
ସେନେ ବି ଡାକିଦେବି କ୍ଲାଏଣ୍ଟକୁ ବି ଡାକିଦେବି ସେଦିନ।
ହଁ ହଁ ଆପଣ କଥା ହୁଅନ୍ତୁ ତାକୁ
ଆଜ୍ଞା।
ଡାକନ୍ତୁ ସେ ବି ଇନଭଲ୍ଭ ହବା ଦରକାର ଜାଣିବା
ଆଜ୍ଞା।
ଦରକାର ଠିକ ନୋ ଇସ୍ୟୁ ଆଉ ହଁ ଇଏ ସେଦିନ ନେହା ଫାଇଲ କରିଦିଅନ୍ତୁ affidavit. On the next date, the husband is also directed to bring an affidavit on his property and financial status by way of affidavit following the decision in Rajnish versus Neha. Also bring an affidavit of your property.
present income at that time.
Oh, that you have to understand. ଆମେ ଆଉ କହିବୁ କି ବର୍ତ୍ତମାନ ରଜନୀଶ ନେହା ପଢନ୍ତୁ
ଆଜ୍ଞା।
ଜାଣିଛନ୍ତି there is a decision Rajnish Neha 2021 Supreme Court fixing guideline how to determine the compensation aspect.
ମୁଁ ଦେଖିନି।
ହଁ ସେଟା ଆପଣ ତ ସର୍ଭିସ ସାଇଟ୍ ରୁ ଆସିକି ମ୍ୟାଟ୍ରିମୋନିଆଲ ଧରି ପକେଇଲେ ଆପଣ ଜାଣିବେ କୋଉଠୁ ଆମେ ଏତେ ଇଣ୍ଡିକେସନ ଦେଲୁଣି therefore ଆପଣଙ୍କର ନେକ୍ସଟ କ୍ୱେରି ଆଉ ହବା କଥା ନୁହଁ ଆପଣ ସିଧା କହିବାରେ ରଜନୀଶ ଡିସିସନ କଣ ଅଛି ମ୍ୟାଟ୍ରିମୋନିଆଲ କେସ ରେ କିଏ ବସିଛନ୍ତି କଣ ହେଇଛି କି ସିଆଡେ ନା ଆଉ ଆପଣ କହିବେ ସେତେବେଳର ଦେବି ନା ଆଜିର ଦେବି କାହିଁକି ଆମେ ଆଉ 10 ବର୍ଷ ପରର ଇନକମ ନ ନବା
ସେତେବେଳେ ଇନକମ ଟା
Please,
ଦିଆ
please,
ହେଇଯାଇଛି ତ ମୁଁ
please,
ସେଇ
please.
କଥା କହିଲି।
Yes, next.
Item 10,
My lord, on behalf of Mr. Deepak Kumar Pani, on behalf of Mr. Deepak Kumar Pani,
Pardon?
on behalf of Mr. D.K. Pani, on last occasion, your lordship has directed to take instruction regarding settlement of dispute between both the parties. Accordingly, we have informed the appellant, but no instruction have been received.
You are for appellant?
My lord. But there,
My lord, I have appearing for a respondent. Yesterday, the Lord and Counsel appearing for the appellant, Mr. Raut, told me that his appellants have a positive response towards settlement, but they have some.
कितने दिन ने
So you want
One
the
week.
time?
My
कितने
lord,
दिन
they
में?
wants
1 week.
1 week.
My lord.
Next Tuesday. Place the matter next Tuesday as the parties are already in attempt of settlement of the issue.
Okay.
Item 11.
Item 11, last occasion, as per lordship directed, the appellant husband deposit 2 lakhs, the name of his daughter, my lord, and lordship further directed to pay another 2 lakhs rupees.
That 2 lakhs has been released.
He applied.
ଆଉ 2 ଲକ୍ଷ ଆଣିଛନ୍ତି?
ଅଫିସିଆଲି ଜିପିଏଫ୍ ଆପ୍ଲାଏ କରିଛି।
ହଁ ଆପଣ କହୁନାହାନ୍ତି ତାଙ୍କୁ କାହିଁ ଆଣିକି ଆଗରେ ଛିଡା କରେଇଛନ୍ତି?
She applied for the GPF loan, madam.
ହଁ?
GPF applied for GPF, madam.
ଜିପିଏଫ୍ ଆପ୍ଲାଏ
Yes,
କରିଛନ୍ତି?
I
ତାହେଲେ ଆର
have
ସପ୍ତାହରେ ଆଣିବା?
documents.
ଆର ସପ୍ତାହରେ ଆଣିବା?
She needs, my lord, 8 weeks time, my lord, because
8 weeks time, why?
there is sanction. Se kuch nihati at least 1 month time nihati darkar
ସେ
sanction.
କଣ କରୁଛନ୍ତି?
Health worker, my lord. Medical service, my lord.
ସର୍ଭିସ କରୁଛନ୍ତି ପରା?
Yes, madam.
ହଁ ଆଉ 2 ଲକ୍ଷ ଟଙ୍କା
She try other sources, but unable to.
beggar borrow bring 2 lakhs rupees next week. Otherwise will be constrained to direct for attachment of salary.
More time, maybe. Some more time. At least 4 weeks time. Like the last
No,
time.
sorry. Yes. There is no compliance of the direction of this court. Dated 8/8/2023.
Some more time.
Counsel for husband in the presence of husband seeks adopts delayed deleterious practices. There has been even filing of application indicating petitioner is in attempt of getting further money through GPF source. Right. ଏଇଟା କୋଉଥିରେ ଅଛି? ଆଜି ଦେଲା ମୋ କୋର୍ଟରେ ଅଲଗା ଦେଖା ହଉଛି। ନାଇଁ ପ୍ରେୟରଟା ଦେଖେଇବ। ସେଠି ପ୍ରେୟରଟା ଅଲଗା ରହୁଛି। Yes, this court considering such request through Matta 30 of 19. Sorry, IA arising out of Matta IA arising out of Matta 30 of 19 filed today being registered by the registry. This court declined to grant 8 weeks time. Adjourn the matter to 28th. Permitting the petitioner to deposit the further sum of rupees 2 lakhs in this court. It is made clear in the event petitioner fails in depositing the amount, On the next step, this court will be constrained to find alternate mode of recovery. Considering the petitioner is a government employee, I would have registered by calling. This is an I filed in court. Registry directed to register the same. Tapore order kahaba. Both the memorandum appeal, I applications be kept on record.
Obliged. Item 12. Obliged.
May I please, your lordship?
Yes,
I am for the appellant. I am for the appellant wife.
you are for the appellant wife. Yes, what happened to deposit?
It is draft is ready.
Diyandu,
Draft.
file karandu.
File kar registry with the affidavit asset liability. I will file today.
File karuchandi.
Aji kari.
No, other day we have decided at least you pay a sum of rupees 10 lakh
10 lakhs
50,000 in favor of the
in the name of the child.
in the name of the child, so that it will be kept fixed deposit.
Yes, yes. That is ready. I will submit it today in the
Now,
registry.
15 lakhs already released since long.
Yes, ma'am.
15 lakhs already released since long. And he also undertakes to, that affidavit you should have brought.
Joint affidavit, your lordship directed, since she is not present today, so it
She
cannot.
has not come.
No.
No, my lord, because the son has, hand has been broken and the
Oho.
exam schedule today is tar parikha achi. Ta
Tahle
hatoda
କୋଉ ଦିନ କରିବା କୁହନ୍ତୁ?
your lordship may
22nd, any date.
your lordship may put it to 28th or 26th any.
20, your lordship will find that his examination is up to 22nd of August. So 23rd or
20 ସେ ଟଙ୍କାଟା ଦିଅନ୍ତୁ।
ଆଜି ମୁଁ ଡିପୋଜିଟ୍ କରିଦଉଛି।
ହାଁ?
ଆଜି ମୁଁ ଡିପୋଜିଟ୍ କରିଦଉଛି।
କୋଉଠି ଫାଇଲ ଡିପୋଜିଟ୍ କରି ରେଜିଷ୍ଟ୍ରି କରିବେ?
ରେଜିଷ୍ଟ୍ରି ଫାଇଲ କରିଦେବି। The affidavit which your
This
lordship
matter has to be closed, Mr. Counsel. You have to understand this matter has to be closed for the reason you had already taken away that 15 lakhs which was deposited in the judgment. Challenge.
Admittedly, my lord,
So
admittedly.
therefore, you must have earned some interest on that.
My lord.
It is 4 years back. Now he is again volunteering 10 lakhs.
My lord,
10 lakh
father,
50,000.
10 lakhs 50,000
the father,
also the study expenses.
And the study, balance study expenses. So you file an affidavit.
Yes.
Indicating all these things.
Yes, ma'am.
Let us take the matter tomorrow. Let us take the matter tomorrow for this order at least. We'll further tune the order sheet. Then now khali rahijibo joint affidavit rahijibo
khali joint affidavit
kahi linger karibo kahi.
My lord. My lord.
Case is almost closed.
Yes.
My lord.
It's only joint affidavit giving an undertaking that yes, she will allow the gentleman to have the visiting right to the child.
She has some grievances regarding the father of the present.
How grievance kono tonka nella?
Respondent has assured to give him a apartment at Bhubaneswar and some gold coins are present.
Oh yes, now apana godo lambe arambho kale.
No, so that's why your lordship was directed to remain present.
Then in that event, you recall the earlier order.
No, my lord, he also cooperated my lord and senior brother. I have intimated him that.
So tentatively 25th.
My lord.
Tentatively 25th.
My lord.
And come tomorrow with that affidavit.
Yes.
Place the matter tomorrow as the. Okay, this court records the submission of Sri Patnaik that there is already preparation of the bank draft to the tune.
Bank draft as well as the affidavit of asset and liability.
Bank draft to the tune of rupees 10,50,000 in the name of the child involved herein. Further, there is also a preparation. There is also preparation of an affidavit. Sorry, the joint affidavit is in progress.
Yes.
In progress, could not be shown, but the wife has been having some inconveniences, and the minor child also at the same time facing his examination schedule. There is clear statement by the counsel for the wife that examination, as per the examination schedule, the exam is going to be over by 22nd.
22nd of August.
22nd of August. Hello. This court direct the counsel for the husband to bring on record the draft affidavit, the draft already prepared. Place the matter tomorrow for further orders, for further direction. Kal ke aso.
Okay. My lord, day after August 1.
Pardon?
Day after 2.
Day after tomorrow.
Day after tomorrow ଆପଣ ଲାଭ କଣ ହବ?
My lord,
ଆରେ ଆପଣ ଫେଭରରେ ଅର୍ଡର ହଉଛି କାଲି ପାଇଁ ଆପଣ day after
August
tomorrow
tomorrow.
କଣ ଅନ୍ୟମନସ୍କ ରହୁଛନ୍ତି କି?
My lord, August.
ସେମାନେ affidavit ଦେବେ ସେଟା that will be on record, order will be dictated.
ସେ affidavit ଟା ଆସିବ ସେଦିନ ଆମେ will grant time.
My lord,
ଆପଣଙ୍କର
15th
date ଆପଣ
August.
next
ଆପଣଙ୍କ
date
ଅସୁବିଧା ଅଛି?
ନାଇଁ 15th August.
କାଲି ଛୁଟି ଅଛି।
15th
ଆରେ
August.
tomorrow ମାନେ ସେଟା 16
ହଁ ମାନେ ତୁମର ମାନେ day after.
Okay. Okay.
ଠିକ ଅଛି।
next working day.
କ୍ଲୋଜ କରିଦିଅ ଆଉ ତାପରେ ବଢେଇବ ଆଉ 15ଟା 15 ହେଲା ଉଠିଯିବା। Rest of the matter ଏଗୁଡାକ
This matter is
item 13 ରେ କଣ notice refuse ହେଇଯାଇଛି?
notice sufficient ହେଇଛି ସେମାନେ appear
My lord,
କରିଦେଇଛି although
my lord, I am appearing on behalf, I am on VC, my lord.
ଆଗ ଆପଣଙ୍କ ନାଁ ଟା କଣ? ଦିଲ୍ଲୀପ ସାହୁ?
Dilip Kumar Sahu, my lord.
Okay, all right. Shri Dilip Kumar Sahu is not in proper attire. This is not a dress code in appearing in court, high court matters.
My lord, I am
This
due
unfortunate
to ligament
incident is still happening, is happening even after 100 such orders. Okay. See, the matter stand adjourned to next week. In the meantime, Shri Dilip Kumar Sahu is directed to make a deposit of ₹2,000 in the Bar Association Welfare Fund.
My lord, my lord, pardon to mention, my lord.
By day after tomorrow.
Due to joint pain in my knee, I am suffering, my lord. That's why I am not attending.
Sorry, you should not have appeared.
my lord interim order to
Day after ଆସିବ next Monday ଆସିବ.
my lord just one request Wednesday ଆସିବ my lord.
Next Wednesday.
My lord.
All right, next Wednesday.
My
interim
lord,
order
I
to
am
continue.
suffering joint pain, my lord. My knee has been fixed, my lord. That's why I am not attending.
Then you should not have appeared.
my lord interim order to continue.
Interim
My
order.
lord, I have, pardon, my lord, I want to appear, but my pain, my knee
Sorry,
pain, I am
you
suffering.
should not have. You should have blocked it simply. Never appear, never try to appear. This court at least has passed hundreds of orders.
Last occasion also I am in pain, my lord. That's why I am.
AD returned from the sole respondent after valid service again.
I'm appearing LRC.
M. Soumya Ranjan Pradhan and associate have already appeared on behalf
Yes,
of
LRC.
respondent.
Yes.
Okay, there is appearance complete. 23 matrimonial appeal ହେଇପାରିବନି.
My lord, your me only one point of law is involved.
That's
ମୁଁ
right.
cruelty ground ରେ ନେଇଛି ପିଟିସନ ଫାଇଲ କରିଛି କୋର୍ଟ କହିଛନ୍ତି ପ୍ରୁଫ ହେଲା ବୋଲି ଏଷ୍ଟାବ୍ଲିଶଡ ତାପରେ କହିଛନ୍ତି ନା ତମେ ନନ୍ ଜଏଣ୍ଟର ପାର୍ଟିରେ ଡିସମିସ୍ କଲ
Hearing ହବ ନା ନାହିଁ?
ସେଟା ଶୁଣିବେ
Hearing ହବ ନା ନାହିଁ and a judgment to come or not.
ଆଜ୍ଞା
So understand, my timing is running out.
So one thing LRC, I pray LRC.
No hearing of
If LRC,
this is a matrimonial appeal of 20.
ରିମାଣ୍ଡ ପାଇଁ ଆପଣ ଆଗ୍ରି ଅଛନ୍ତି?
no, my lord.
Hearing ପାଇଁ?
Remand ପାଇଁ ସେଟଲମେଣ୍ଟ ପାଇଁ ଚାହୁଁଛୁ ମାନେ ୱାଇଫ ଅଛି not
Settlement,
intent.
ଆପଣ ୱାର୍କଆଉଟ କରିପାରିଲେ ବହୁତ
Fine.
ଭଲ କଥା।
Yes, sir.
Settlement କଲେ memo ଦେବେ କି
ଆପଣ
case ଦେବେ ହେଲା।
affidavit ଦେଇପାରିବେ,
ସେମାନେ
ମେମୋରେ ଦି ଜଣ ଯାକ ଦସ୍ତଖତ କରି ଦେଇପାରିବେ।
This is an appeal of
Work it out.
ପାଇଁ senior brother.
This
Work
is
it
an
out.
appeal of 23. There is no time for hearing such appeal. Matter is delisted. Considering submission of Sri Barala that there is attempt for settlement outside court. this court observe in the event any settlement, there is possibility, any settlement is achieved. Settlement between the parties is achieved. Liberty with the either side counsel to bring on records of settlement and request the court for early listing of the matter.
Obliged. Obliged.
That appeal number one, each appellant have died in both the appeals.
Raurkela matter.
Lordship, I'll give the number.
Yes.
I'll give the number to the court
This
master.
matter should not come, rather that matter should have come.
There is
Lordship.
some confusion actually.
That
That day the Lord-
confusion re pade eschi.
My lords,
Now release karo.
I'll provide the number to the court master.
ଦେଖିବା ଆମେ ବି Thank you.
My lord, may I be permitted to place on behalf of Mr. N. Lenka?
The fast contempt. Yes, fast
Fast
contempt.
yes,
no?
fast
Ah, right, right.
Item number 2.
May I please, your lordship? The petition.
OSS case disposal.
On several occasions before this Hon'Ble High Court, my lord.
It's only for disposal, targeting.
That is the OSS, the revision is pending before the member. As per direction given, he has filed. Remember, now your lordship already passed a number of cases, but
That's right. He is to follow the judgment.
Yes, sir.
Okay, what is
What
the
a
case
stipulated
number?
period, my lord.
Well, disposal of 322 of 19.
OSS cannot
Okay,
double
within 4
nine.
months. But however, keeping in view the settled position, if any, through WPC 1608 of 14. On the copy of order of this court as well as certified copy of such judgment provided by the petitioner.
What a stipulated period, your lordship. Can fix it? Already 2 years pending there. What a stipulated period.
4 months sufficient only, 4 years for
Sorry, my lord, sorry.
4 years
All
for
right,
there.
all right. I could not
The
hear.
young counsels are doing better than you. ये सब मैटर रे पिला आछुनी फटकिना छिडाले ऑर्डर ही गलानी चली गलानी अब 4 मास देली आपण कहले आउरी टाइम
नहीं, नहीं, सर, sorry.
4 वर्ष कर दवा
नहीं,
से सीनियर काउंसलर तो अवश्य आओ
सुनी पाली।
यस नेक्स्ट
Item 3.
May I please, your lord?
Item 3, my lords, I'm appearing for the opposite party arising out of a RERA appeal. I'll file a petition, my lords, of objection, and all these my lords may be given some more time.
Counter is there.
No, counter I'm not.
You want to bring counter?
Yes, ma'am.
All right, counsel for prisoner wants to bring counter. आगुरु भी दिया हितला समय बोधे
हाँ गोटे तो टाइम नेतिले एटा पूरा टोटली रेरा अपील टा पूरा मूलरू टोटल अपील और ओरिजिनल पिटिशन सबुडा
No, very short question involved. Mr. Mahapatra, the appellate authority has taken into account certain new materials.
Yes.
Which are neither here nor there.
That exactly, my lords, I'll bring.
Then what is the role of the appellate authority?
That I understood,
It
madam.
can fall in the trap of the additional material.
Understood, my lords. I will bring
Remain
it.
the matter.
I will bring it, my lords, the contingencies, and I will also bring it that some of the materials were there before the court below.
All right.
No materials were produced before the.
Okay. Kete 2 weeks रे करिवे?
हाँ तो टिके अधिका time.
Place.
Out slight more time.
ଆଉ ଅଧିକା ହେଲେ
2 weeks. 2 weeks.
2 weeks ଭିତରେ
counsel for the you are for development
My
authority.
lords.
Development authority will seeks at least 3 weeks time to file counter. In its challenge to the contention of the petitioner that materials completely outside has been taken into account by the appellate authority is not correct. Okay, it is in this circumstance, this court permit filing of counter within 3 weeks. Matter to come immediately after filing of the counter.
Your lordship 2 weeks ଆଜ୍ଞା ରାଜି ହେଲେ ଆପଣଙ୍କ ଇଏ ପୂର୍ବରୁ ଆସୁ ଆଜ୍ଞା ଗୋଟେ ଥର I will try my luck.
3 weeks ପରେ ଗୋଟେ date ଦିଅ ଦେଖିବା।
2 weeks ଦେଇକି ଆସୁ ଆପଣ ବୁଝିଥିଲେ ସରିଯାଇଥିଲା।
Mr. Mahapatra 2 weeks ପରେ ଗୋଟେ date ରେ ଆସୁ ଦେଖିବା ଆପଣ ଯଦି establish କରିଦେବେ ତାହେଲେ dismiss ହେଇଯିବ ଆଉ କଣ। 2 weeks ପରେ ଗୋଟେ date କରିଦିଅ। Time granted 2 weeks. Here. Yes, 4.
Item 4.
Oh, right.
Order, revisional order under section 23A of the OLR Act is under challenge.
OLR proceeding कौन है उड़ा का provision under what provision of law?
23A.
Huh?
23A of the OLR Act. Milord, the
23A
of the OLR.
23A applicable no?
Yes, appeal revision, everything has been.
Appeal revision all over.
Okay. No, there is some clerical errors, and so I have not.
Okay, amendment file kurchun.
Not the time in the.
ताले आगो amendment करो तू तापरे.
An amendment I have also filed.
Amendment in the cost title only.
No, so some typographic errors are there. Formal amendments.
Typographical error कोठी? Body of the petition.
Yes, body of.
Okay, this is an application for amendment filed in court.
Copies of.
Considering this is an attempt pre-admission stage, this court allows the application. There is already filing of consolidated writ petition which we kept on record. admit कर दिया ना. But have you filed the certified copy of these orders?
Revisional orders are filed. And
They
also,
खाली revision टा certified copy.
all other two also I will file today.
ओला revision ର certified copy टा ଦେଇଛନ୍ତି. All right, admit कर दियो. Notice ଟା accordingly କରିବ.
Let's stay up.
Admit कर दे ला. Second case रे कौन amendment अछि?
No amendment.
Second case रे no amendment नहीं?
No amendment. Here I file a petition to dispense.
Same situation. Say revision order challenge
Again.
Same.
But where is the certified copy of revision order?
Well, they are in common judgment passed. In first case, the common
Okay,
judgment.
this is
Dispensing file करছো.
I have filed a petition dispense with certified copy.
status को करिबा.
आगे.
इटा ये मिसकेस टा तारी देरे फाइल जी.
आगे.
No, एथिरे 363 रे.
Second matter रे miscase file करছো for amendment.
मिसकेस नहीं तो.
First case टा नहीं, second
First case miscase अछि.
first case टा अछि. Second
First case रे मिसकेस अछि.
आगे first day.
देखिलो.
अछि I there.
अछि. Status को in respect of the disputed property.
53 of 2023.
Right. Second case रे.
I have filed a petition for dispense.
You are filing the certified copy.
File
ना इटा appeal रो. Revision रो काई.
and revision no connect.
ताले exemption file करिवे ना नहीं.
करछिन.
File करछि.
काई
Dispensing file करछिन कोन.
Dispense with the certified copy.
हम पाखु आछि.
आगे आज आछि.
ना इटा stay होगी.
Stay out.
State dispensing गोटे order रे केम दबो.
ना सर आउट 29 अछि.
Dita आई अछि.
Dita petition अछि.
All right, this is 11830 hala. This is an
11829
application for dispensing with filing of certified copy of impugned order. The revisional order at annexure 10. Considering certified copy of such order is already borne in read petition number so and so hala. This court allows this application. Tapare admit karibo. Miscase stay of status quo in respect of disputed property.
Obliged.
Item 5.
My lord, may I please? This is the application. The petitioner land is adjacent with the government land. Petitioner, he was using the government land as a right of park.
You want eviction?
Yes. Palahandi Adivasi Sangroh has put a board over the land and they have occupied the land, my lord.
Okay, under what provision? Eviction will take place under what provision of law?
We are the government.
Annexure 6 pending achi. Mr. Ghosh.
Again.
Annexure 6 is pending.
Pending.
Prayer court the annexure 6 directed to be
Collector.
considered, but in the involvement of the party likely to be affected. Party and parties likely to be affected. By completing such exercise within a period of 4 months. It VC court appear person the lecture. Mr. Singh Dev, SS Singh Dev. ଏଟାକୁ ଏମିତି କାଇଁ ଲଗେଇଛନ୍ତି ବ୍ୟାଣ୍ଡ ଟାକୁ ପ୍ରୋଟେଷ୍ଟ କରୁଛନ୍ତି ଓ ଗାଉନ ଖସି ଯାଉଛି ବୋଲି ବାନ୍ଧିଛନ୍ତି ତାକୁ ଟେଲର 6 ରେ କଣ ରିକ୍ୱେଷ୍ଟ କରୁଛନ୍ତି
ट्रांसफर କରିବା ପାଇଁ ମୋ ନାଁରେ ଯେ ମୋ ଶ୍ୱଶୁର କରିଥିଲେ ट्रांसफर
ଡେଭଲପମେଣ୍ଟ ଅଥରିଟି କପି ଦିଅନ୍ତୁ ତାଙ୍କୁ
ଦେଇଥିଲି ସେ ଇନଷ୍ଟ୍ରକ୍ସନ ମୋ
କରିଦବା ଏକ୍ସଟ୍ରା କପି ସର୍ଭଡ ଅନ ସିଦ୍ଧି ମହାପାତ୍ର who appears for the development. Oh, already there also already.
Last date they solved.
Already appeared for the development authority. Prayer court karike annexure 6 on the same issue. Directed to be considered within 2 months.
2 months.
Item 7.
In this case, he has given that application to the allotment officer. Let him give an application to the secretary afresh. That will be better.
6 रे
annexure 6 रे देखो allotment officer BDA ଦେଇଛନ୍ତି he has no authority
ताले ଆମେ ତାଙ୍କୁ direction ଦେଇ दवा एटा consider करिवे के करिवे
party that is opposite party number direction to opposite party number minutes
secretary 1
House secretary housing and urban development department will know secretary BDA will do that he is not a party he is not a party
party कर दियंतु
make a party
on oral request so and so is made as a party OP number
4
4 habo bartaman 4 hela so 4 is directed कर दियंतु नहीं कि brief रे in court हला. Yes. Next. Eta ताले हबो copy of the brief be served on OP number 4. On a copy of brief be served on OP number 4. He shall do well in giving a lawful disposal to the same within 2 months. Yes.
Item 7.
Demarcation application pending.
Annexed 2, my lord,
Okay,
before
answer
opposite part
two
number 4.
reflects there is pendency of demarcation proceeding before Tahsildar Patamdela. So 3 months giving opportunity to opportunize.
Item 8.
Annex 8, 3, my lord, pending before the opposition, not 2, my lord.
Pardon?
My lord, in this case, my lord,
Okay, representation pending ଅଛି କଣ ପାଇଁ?
ସେ ଗୋଟେ boundary wall ଟାକୁ ଜଣେ ଲୋକ
So demarcation.
demarcation ହଁ ସେ boundary wall
Demarcation case ରେ Annex 5 ରେ already notice ହେଲା କଣ ହେଲା ତାପରେ କିଛି ହଉନି?
ସେ FIR କଲେଣି
Okay, it is alleged through Annex 5 series. Even after putting the parties for demarcation exercise repeatedly, there is no completion of the demarcation exercise. In the perusal of the documents Annex 5, this court find there has been even police requisition for undertaking such exercise. Considering there is sufficient delay in such matter and in disposal of the writ application, this court direct Tahsildar Biswanath to complete the exercise in demarcation case 171 of 22, ensuring police protection for completing such exercise at least within period of 2 months from the date of communication of order. A copy of order, petitioner is also permitted to serve copy of order of this court on the IAC Panikoili for extending his cooperation in the demarcation exercise by Tahsildar OP number so and so.
My lord, in this case, my lord, also prayed the collector. In this case also, my lord, petitioner pray before the honorable court to direct the collector before they are constructing. My lord, they are constructing a boundary wall without drain and road.
ଆଜ୍ଞା ଏଠି ମୁଁ ପାଠ ପଢେଇବାକୁ ବସିନି ଆପଣ demarcation କୁ ଯାଇଛନ୍ତି ଆପଣ ମୋଠୁ ନେବେ order boundary wall ରେ injunction. How are you submitting such?
Sorry, sir.
Completely outside jurisdiction.
Yes, sir.
ନୂଆ ଓକିଲାତି କରନ୍ତୁ ଶିକ୍ଷା ପାଠ ଶିଖିବାକୁ ଚେଷ୍ଟା କରନ୍ତୁ ଆପଣଙ୍କର ଅସୁବିଧା ଅଛି ସେଥିରେ କିଛି ସନ୍ଦେହ ନାହିଁ କିନ୍ତୁ ଅସୁବିଧାଟା କୋଉଠି ଉପଲବ୍ଧ କରାଯିବ ଡିମାର୍କେସନ ଆସିଲା ପ୍ରୋସିଡିଂ ଟାର୍ଗେଟ ହବ ଇଞ୍ଜଂକ୍ସନ ଦେଇ ଦିଅନ୍ତୁ ମତେ ପଢନ୍ତୁ ମୁଁ ଏବେ ଅଳ୍ପ ଦିନ ତଳେ ଜଜମେଣ୍ଟ ଦେଇଛି ଡିମାର୍କେସନ ରେ ତହସିଲଦାରର ରୋଲ କଣ ଇଟ ମେ ନଟ୍ ବି ଏ ଜଜମେଣ୍ଟ ମେ ବି ଅର୍ଡର ଗୋଟେ ୱିକ୍ ବିଫୋର ଦେଇଛି ପଢନ୍ତୁ ସେ କଣ ମ୍ୟାକ୍ସିମମ୍ କରିପାରିବ ଏବଂ ପାର୍ଟିଙ୍କର ରାଇଟ୍ ତାପରେ କଣ ଆସୁଛି ପଢାପଢି କରନ୍ତୁ କାହିଁ ଯୋଉ ଗୋଟେ ଶନିବାର ଦିନ ରବିବାର ଦିନ ବିଶ୍ୱନାଥ ରଥ କଣ ଅର୍ଡର କରିଛନ୍ତି ଦେଖିବା ଟିକେ ମାରିବା ଲାଷ୍ଟ ୱିକ୍ ରେ କଣ ସବୁ ଦେଖୁନାହାନ୍ତି A to Z
Passed by the sub-collector Jaspur, in where the
appeal under what provision of law?
My lord, mutation appeal, my lord. Mutation appeal, my lord.
Revision ଅଛି ନା ନାହିଁ?
Revision
ଅଛି ଅଛି
mutation manual ରେ revision ଅଛି ନା ନାହିଁ?
ଅଛି ଆଜ୍ଞା ସର୍ଭେ ସେଟଲମେଣ୍ଟ ଆକ୍ଟ ରେ ଅଛି
So OSS ରେ 34 ହେଇଥିଲେ ବି ତା ଦେହରେ revision ଅଛି
ଆଜ୍ଞା ଆଜ୍ଞା
mutation manual ରେ ବି revision ଅଛି ଦେଖନ୍ତୁ 92 ନା 96 ଦେଖିଲେ
ସେଟା
ହେଲା 42A
ନାଇଁ ସେଟା ହଉଛି OSS
servant settlement ରେ
mutation appeal ଟା ବି ସେ ଏଥର କରୁଛନ୍ତି
mutation appeal revision କରନ୍ତୁ expertise order ଅଛି କି ଯଦି expertise ଥିବ ତାହେଲେ
ନା ନା contest ହେଇଛି ସେ କେସ୍ contest ହେଇଛି competent court କୁ ଯାଉ civil court କୁ ଯାଉ ଡାକୁଛନ୍ତି
complete revision remedy.
My lord, I may
permitted to withdraw the writ application with liberty to bring a revision at least within a period of 10 days. In the event a revision is brought, along with the grounds raised herein, the revision will be decided on its own merit.
Get back the certified copy.
Yes, all right. On oral submission of learned counsel, the certified copy of the appeal order returned, but however, after returning a Xerox copy of the same.
Xerox copy already there.
Next.
Item 10.
Millard covered matter honorable court order annexed 6 ରେ ଦେଇଛି
This case is not accepted even.
No, Millard. Only
Why do
direction
you
is
find that miscase?
I have a lawful right title interest
Okay,
over
okay,
the
all
land.
right, all
It is
right.
not
Amar se jo
recorded.
division bench, single bench order re dauchandi. Achi it is copy. Right. Page 36 order, huh? Okay.
Item 11,
Please, your lordship. This is second round of approach before your lordship. This is my
Second round mane first round re hitla representation consider.
Yes, my lord.
Reject he gala.
Yes, ma'am.
What was the request involved?
My request was for allotment of additional land behind my leasehold land. As per your
Behind your
lordship.
road, ମୁଁ ତ ଗୋଟେ order କରିଛି ଯଦି
Yes.
ତାକୁ otherwise କିଛି utility ନାହିଁ
Yes.
ତାହେଲେ ତାଙ୍କ ନାଁରେ premium ନେଇ କରିଦିଅ ବୋଲି।
Yes, but now it is rejected on the ground, page 36, your lordship may kindly see. He says, since the original lease has been determined because of its non-user, so this cannot be settled. And against that,
You are not the non-user.
no, I am there, I am staying there.
You are a user.
Yes,
So user is not claiming here the adjustment of the land. Leaseholder is not claiming the adjustment
no,
of
because
the
I am
land.
a transferee from the lessee.
Okay, notice ଦବା କଣ କରିବା?
ଆଜ୍ଞା, notice ନବା ଖାଲି third party right create କରିବେନି।
Yes, in the meantime there may not be. କାଇଁ ଆପଣ compound wall ବୁଲେଇ ଦେଇନାହାନ୍ତି କି?
ନା,
ଆଉ
ସେଇଟା ଭୁଲ କରିଦେଇ।
Okay, all right. As an interim, there should not be creation of third party right in the pendency of the writ application. In so far as property schedule code ଦେଇଛନ୍ତି।
But I have given. In impugned order itself, it is there.
ଏଇଟା କରିଦିଅ 14 foot into 20 foot adjacent to SCR plot number 53 ମୌଜା ଖାରବେଳ ନଗର Bhubaneswar by DRG drawing DRG number C-3222.
Oh, bless me.
item 12,
May I please, your lordship?
Mr. Mishra.
Madam.
No, here I am telling you. Your young counsel is doing well. Why you came here? She is doing well.
She was supposed to go to the civil court. In fact, civil court,
Okay,
that
all
court
right, all
didn't
right.
function.
Encourage her.
Yes, ma'am.
Yes, Mr. Mishra, senior counsel. Yes.
My lord says.
ହସିଲେ କାହିଁକି? ମୁଁ with all respect ମୁଁ କହିଲି ଆପଣ ତାକୁ ହସରେ ଉଡେଇ ଦେଲେ।
ନାଇଁ ମୁଁ ହସରେ ଉଡେଇଲିନି ଯେ ଆପଣ ସେଇଟା କହିବା ଦରକାର। Your lordship's blessings and affection is more important than
it is always there.
Addressing me as senior counsel. My lord, जो सो मोटो जो settlement power एटा गोटे matter सेही order रो आसीतला on 9th. Your lordship said गोटे opportunity दवा नले रीट अपील कर दउचंदी तांको दिया है कि मंडे पय आसिया पय से केसटा कोहा हितला सेथरे भी मु जजमेंट रो कॉपीटा आपन रो देइतली मो एसोसिएट अछि आज आ गोटे कॉपी भी दबो से जो आपन कहचंदी सो मोटो आ हेई परिवनी that decision is a reported decision. If your lordship kindly permits, my associate is there. He will produce it 2022 2 OLR 709. Connected case जो 9 आसला सेथरे भी से कॉपीटा मु देइतली सरकारी वकील देइतली and I produced to your lordship that is WPC 24566 of 2020.
Mr. Sahu ready?
I will examine. I have already examined.
So he wants to examine. Let it come on Friday.
No, I have already examined.
He has
I have
already examined. All right then.
Para 9 of the judgment.
ସେଇଟା କରିବ
Para 9.
So this will follow?
Paragraph 10 of the lease deed. But here in this case, the lease deed has not been filed. Only relying
on record
cell deed anti record re cell deed
only relying the cell deed.
Annexure 1 re cell deed
cell deed nahi
ଆଜ୍ଞା ଅଛି
relying on the basis of cell deed lease deed nahi
but that was on the basis of the lease deed.
Yes.
So that is the inference you are drawing. So what will be the difference in law?
lease deed ta file kar diyo
ନା lease deed को डेटा cell deed रे ହେଇଛି एटा सत्व स्थितिवान
सेल टा कोन pursuant to a lease deed?
No स्थितिवान सत्व रे
just a cell deed.
स्थितिवान सत्व एटा cell deed is much better than a lease deed. सेटा lease deed रे ହେଇtla
ताले Mr. Mishra, you argue, I will give a judgment on that also.
My lord, your lordship has been pleased to hold.
No, the principle may be followed.
My lord,
But there a lease deed was considered and a principle has been ascribed. So
Principle
now in same principle may be followed,
Right.
but here it is in respect of a sale deed condition.
Right.
So
Ma'am.
therefore you argue, let me give a judgment on that.
I am placing it here before your lordship on annexure 1.
ଆଜି ନାହିଁ ଶୁକ୍ରବାର ଦିନ
ତାହେଲେ ଆର କେସଟା ବି ସାଙ୍ଗରେ ନେଇ ଆସନ୍ତୁ ମୁଁ ପର୍ସନାଲି କରିବି ଫିଜିକାଲି
କେତେ ନମ୍ବର
এটা WPC 24 this
Item
is
15. 15. Today list. Item 15.
ଅଛି ଆଜି
ଆଜି ଅଛି item 15.
Oh, I'm sorry, I have missed it then.
Item 15 ହଁ ଇଏ same council
24566
ତ ଦିଟା ଯାକ ଏକାଠି ନେଇ ଆସିବା ଶୁକ୍ରବାର ଦିନ
ଆଜ୍ଞା ଆଉ ଯଦି ଶୀଘ୍ର ଆଣିବେ ଗୁରୁବାର ନ କି
ହେଲା either 13 and 15 to come again on
ସେଇ
Friday.
ଟେଷ୍ଟରେ ଆସୁ
The matter will be finally disposed of at the fresh admission stage.
Deeply grateful, man.
Examine if there is no hurdle, we can just change that one and
pass.
share kardava. All right, I am disposing.
Deeply grateful, man.
Okay.
Yeah, your point.
ई पोर्शन टा केवल रहिबनी बुझिले से लीज पोर्शन टा पारा 9 रो लास्ट पोर्शन टा रहिबनी हला so 8 7 8 will all be relevant.
Yes.
ये 6 ru कर दबो para 6 onwards will be maintained except the 3 lines omitted he jo 4 lines last 4 lines in para 9.
Yes, yes.
ହେଲା ଆଉ ଏଠି annexure କେତେ ଅଛି impugned order
ହଉଛି annexure 3
ହଁ so that will also be there ତିନି ହବ ବାକି principle ତ ଯାହା ହେଇଛି ହବ
principle of law your lordship has been pleased to lay down
okay all right
15ଟା ସେଇଆ ହବ your lordship ଏକା order
15 ଦିଟା 15 ରେ annexure କେତେ
ସେଇ annexure 3 same order ଆଉ ଅଲଗା order ବି ନୁହେଁ
ଇଏ କିଏ ମ୍ୟାଡମ ଙ୍କ ନାଁ କଣ
सोनाली पाणिग्राही
all right senior counsel SK Mishra assisted by Miss Sonali Panigrahi dita
in fact she daughter of your lordship Mr. Kalpataru Panigrahi
kahara
Mr. Kalpataru Panigrahi
okay all right nahi mo sangare onek se Panigrahi very tall judicial officer decision ତାଙ୍କର ସେ ଗୋଟେ ପାଣି ତାଙ୍କ ପିଲାମାନେ ବି ଡେଙ୍ଗା ଡେଙ୍ଗା ପ୍ରାକ୍ଟିସ ସବୁ କରୁଛନ୍ତି ତାଙ୍କ ଝିଅଟି ହେଲାଣି district judge ହେଲାଣି all right thank you
I think she is taller than me also taller than her father
ହଁ ଭଲ ନାଇଁ ଏ ପାଣିଗ୍ରାହୀ ସବୁ ଡେଙ୍ଗା ଗୁଡା କେବଳ ଆମ ଜଷ୍ଟିସ ପାଣିଗ୍ରାହୀ ଟିକେ ଗେଡା ଦେଇଯାଇଛନ୍ତି ନହେଲେ ବାକି ସବୁ ଡେଙ୍ଗା okay rest of the cases after recess naba after recess
The bill is withheld.
yes any decision on annexure 5
ଆଜ୍ଞା
ହେଇଛି
ହଁ ଦେଇଛି page 23 ରେ ନା decision ନିଆ ହେଇନି
decision ହେଇଛି annexure 5 ରେ
no annexure 5 decision ନିଆ ହେଇନି
क्या ପଚାରୁଛ ହଁ ହେଇଛି କହୁଛନ୍ତି prayer court କରିଦେଇକି annexure 5 since pending before collector Baleshwar is directed to Upinama Swanswara within 2 months.
Item 14.
Item 14, madam, SRP is pending before you.
This is for fresh admission of the proceeding.
Yes, sir.
Item 15. Sorry, 15. Sorry. Item 16.
My lord, sorry, my lord, I'm on VC, my lord.
Yes.
My lord, here my small prayer is, your lordship may kindly turn to page 51 annexure 5. After disposal of 5 mutation cases,
this application was filed by one Purnachandra Raut, but signed by one Rajesh Kumar Raut, bottom, my lord. In pursuant to this application, your lordship may kindly see annexure 6.
Notice has been issued to you.
Yes, then I appeared on 12/7. I filed my objection. Also filed an application by annexure 7, my lord.
What is the main proceeding?
Mutation sari jaichi again. Tapore se ei petition na
Then
deichendu.
what proceeding pending you are asking for taking a decision on entertainability?
Again, say annexure 6, page 52, miss petition case number 1 of 2023. But the certified copy order of the
No, that is the proceeding pending.
Yes. And I have
So,
filed my
no,
objection.
Therefore, I can only say if such a petition is taken up,
Again,
then your objection will be taken up into account.
No, objection mu dei sarchi.
That will be taken into account.
Plus gote petition deichi maintainability jurisdiction le suniya pai.
Apo sera ko argue kariବେନି?
Again, Tahsil office again
These are question of law, maintainable haba na haba.
Ja mu deichi setiki etiki
It is
deichi.
open to you to argue. What is this? I don't understand why such petitions are not there.
Again, eparjanta date bi kichi dou nahanti, order ro certified
So
copy dou nahanti.
undisputedly you have been noticed by annexure 6.
Again.
So if you raise the question of maintainability, that will also be decided together.
Your lordship may say that certified copy mate diyantu dou nahanti again mu apply
ଆପଣ ଯେତେବେଳେ ଛିଡା ହେଇଗଲେ ନା କେସ୍ ରେ ମୁଁ ଭାବିଲି କଣ ଗୋଟେ ସିରିୟସ୍ ମ୍ୟାଟର ଅଛି
ନା ଆଜ୍ଞା ଜୁନିୟର କୁ ଦେଇକି
ଆପଣ
କରିଥାନ୍ତି
ଗୋଟେ ଏଇ ମ୍ୟାଟର କୁ କରିବେ
ଆଜ୍ଞା ଭିସି ରେ ମହକିଲ
ସେ
ଦେଖୁଛନ୍ତି
ମହକିଲର ଅବସ୍ଥା ଯାହା ହଉ at the submission of Sri Bagh Landed Council appearing for the petitioner undisputedly involving mutation decision, there has been some application pending by Miss
petition case number 1 of
Miss petition case number 1/23, and there has been already notice by the Tahsildar Balyapur to the petitioner as appended at annexure 6. It is claimed pursuant to receipt of such notice, petitioner has already put off his objection on the entertainability of the application itself by annexure 7. It is on the pretext of pendency of such proceeding, read petition has been brought to this court for taking a direction to the Tahsildar Balyapur for also undertaking the exercise of entertainability of the petition involved therein. For the opinion of this court, since the proceeding is undertaken under annexure 6 herein, it is obvious any ground raised therein shall have to be taken into account and decision therein should come. It is in the process disposing the writ application, this court observed in the final outcome of Miss petition number 1 of 2023, objection of the petitioner by annexure 7 should also be considered and given an outcome.
मते सर्टिफाइड कॉपी टा दियंतु आज्ञा सेटा दोने मु अप्लाई करती कोन ऑर्डर शीट रो सर्टिफाइड कॉपी दो नांती कि डेट दो
को सरकार सर्टिफाइड कॉपी
जो इनिशिएट वाला जो ऑर्डर गुडा को 12 7 रे जो ऑर्डर होला तार किछि दो नांती
that is there in your prayer.
Yes.
Okay, besides the petitioner has also, apart from above, petitioner has also allegation of not being provided with entire order sheet in Miss petition case 1 of 2023. Okay, in the event with any copy application pending in this regard, same may be also considered and by providing the petitioner the entire order sheet involving Miss petition number.
Again.
Item 17. My lord, on behalf of Mr. Tripathi, my lord, pray for next week, my lord. My lord, on behalf of Mr. Tripathi, my lord, pray for next week. My lord, on behalf of Mr. Tripathi, pray for next week.
Adjournment.
My lord.
Not assigned to this bench, my lord.
Okay, all right. Keba aniva? Next Tuesday, next Monday aniva?
My lord.
The OPL matter. My lord, kindly see the prayer.
matter mo court re habani.
No, my lord, kindly see the prayer.
That is municipality matter, my lord. It just
Yes, some OPL proceeding is pending.
hello, it is
Okay, while adjourning the matter to next Monday, keeping in view the request of the learned counsel for the petitioner, registry is also directed to examine the assignment to any other bench if any.
Item 18. My lord, the petitioner was the owner of Sabik plot number 590.
Subune, Mr.
The
Mahathir,
petitioner is the owner of the Sabik plot number 529 under Sabik Khat number 36, measuring on 10 decimals Gharabadi under Stitiban status. Taking his absence in Hal settlement, which was recorded in the government Anavadi Khata, bearing plot number 314, measuring 4 decimals and 6 decimals reduced. Therefore, RP case was filed. You will also kindly come to page 24. At page 24.
No, come to your relief part.
Relief, my lord, taking advantage.
Injunction against OP number 5 to 7.
No. Now the government under 5T for development of the school, they are constructing the gate and road on my road land. As the pota has not been given as per the direction of the commissioner till today, they are constructing this road and gate on my land.
Then you raise there. Why have come to
where I will raise my lord? Is the government?
I am not there to answer. Regis there means you have to find out to whom.
My lord, they are not listening, my lord. Therefore, I have come in property right
Who
now.
is not listening? Where is that application? They are not listening.
And under Article 300, I have a right,
Sorry,
constitutional right. I have a constitutional right, my lord.
Constitutionally, you have a.
My lord, government is.
You may say you have a right over the property.
Yes, my lord. That is
your civil right is being infringed.
It is a constitutional right under Article 200.
Okay. I had this.
My lord, is the government.
All right. Take the decision. It's a constitutional right. I am dealing.
My lord, you will also kindly hear.
No, I am dealing. If you have a constitutional right, it should be protected by appropriate court.
If a private dispute was there, my lord, I could have filed the suit, my lord. If a private dispute had been there, I could have gone to the suit, my lord. Here the government is spending
money.
Why
are you not writing to government?
Your lordship gave liberty to write the collector.
Sorry. I am not there to advise Mr. Mahathir.
I am not seeking advice from your lordship, my lord, but it is a constitutional right. Therefore, I filed the.
Yes. That's why I am giving the order. Take this order.
Yes, your lordship.
Take this order. Pleases. At the submission of learned Sri Mahathir learned counsel for the petitioner. Through the order in RP 3861 of 93. But however, since there has been no issuing of appropriate potta in favor of the petitioner, taking this court to the pleadings in the writ application, the Mahathir alleges when there is already accruing of right over the disputed property in favor of the petitioner, the opposite parties 5 to 7 have no business in.
3 to 7, my lord. 3 to 7, opposite one 3 to 7.
3 to 7 have no business in infringing the right of the civil right of the property. Sri Mahathir also contests the matter on the footing of a constitutional right accrued to him. For the opinion of this court, OP number 3 to 7, 3 to 6, even though are public authorities, for an attempt, okay, while even assuming that such parties are attempting to infringe the civil right of the property, it's a civil right infringement. OP7 also a private party. Okay, even assuming there has been order in favor of the petitioner by Danester 3 in the preparation of record of rights in favor of the involving the disputed land therein in favor of petitioner, and finding that the petitioner is in no mood of bringing such development to the opposite party number 3 to 6 by way of representation, resisting them from their action in the infringement of the civil right of the petitioner. This court find the only forum available for the petitioner is civil forum. In this circumstance, this court declining to entertain a writ application. However, and dismissing the same, however, observe, if the petitioner so advised, he may find out the other mechanism available for the purpose. Yes.
Item 19.
So many similar matter already disposed of, my lord.
Pardon?
So many similar matter already disposed of. I have filed a in view of Narottama Ratha case. I have filed a miscase before the ASO. ASO did not accept the same.
You have already filed?
Did not accept the same.
Oh, you did not accept the more order of
हाँ sir. Second one is similar.
May I please, Your Honor, challenging the action of opposite party number 3 in not disposing the OLR miscase number, madam. Under section 22 of OLR, annexure 3 is pending.
Targeting the proceeding under section 22 pending before OP3 by the OLR miscase 145 of 22. Considering Innoco's request and observing in the event any such proceedings still pending.
In the light of annexure 4, madam,
OP3,
already Tahsildar has.
they may be given a lawful disposal, but however, keeping in view the assistance of the petitioner through annexure 4.
Again.
Through annexure 4. By completing such exercise at least within a period of 3 months from the date of communication of order, if necessary, providing opportunity to party likely to be affected.
Madam, there may be 2 months, madam, because he is a heart operation. Heart operation of the petition.
Heart operation है तार कौन सा पर?
बिक्री हेले
तिपाई ऑपरेशन बेले.
2 months, madam.
Item 21.
ये कौन करिवो ता वकील तो केस करिवो ता संगे पाएंगे.
This is an
legal proceeding we should not give so much restriction. ताको अवस्था कौन सी कौन काम व्यस्त होती. तथापि हम
well, simply prior the OP number 2 is not accepted demarcation application annexure 3, my lord. But director accept my application, my lord.
Annexure 3 demarcation application appears to be pending. La directed OP number Tahsildar
OP number 2, my lord. 2. Tahsildar, man. Tahsildar Kendrapada is not accepting. Annexure 2 is my.
Within 2 months, however, providing opportunity to the boundary tenants.
The second is also that same, my lord. OP number 2. Second item. 21 data cases.
Similar matter.
Similar matter.
Right.
Both are similar. OP number 2 and annexure 3 demarcation application.
Right.
Item 22.
Yeah, past contempt.
22 already complied, Miller.
Complied.
Yes.
Tangoda copy did you
know?
My lord, here my application is not even accepting, so it's not pending. My application is not accepted by the Tahsildar.
Demarcation application not accepted.
Not accepted.
Okay.
Not pending, my lord.
Yes. Requisition involve serious allegation of non-acceptance of the demarcation application by the Tahsildar. OP number 2.
OP number 2, Kendrapada, Tahsildar, Kendrapada.
So
in the event
to any such controversy, this court permit the petitioner to bring the application, appropriate application before OP number 2, at least within a period of 7 days. In the such event, same shall be accepted, then falana.
Complete the proceeding, unnecessary puni asiyo garibo lokota. 2 months vitere sar da bin koi don.
2 months deichi.
Oblige,
Yes.
Due to non-compliance, I have filed this
Okay, now that
application.
compliance is already there.
Comply.
It has to be disposed. Okay, the contempt application involved allegation of non-compliance of order of this court in WPC 28838 of 22. Sri Pandal and counsel appearing for the contender producing instruction memo along with copy of order of compliance established that there are
May I submit one thing?
there will be
Last one what I
already
given my lord, there are two.
compliance. Oh, Mr. Counsel, kepe ଆପଣ କେତେ ବର୍ଷ ଓକିଲାତି କଲେଣି କହିଲେ?
Sorry, my lord.
କେତେ ବର୍ଷ କଲେଣି? May be nearly 15 ବର୍ଷ ଉପରେ ସେ ଡର ହବ। କୋଉ ଲାଇନ ରେ ହବ କହିଥିଲେ?
ନା 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 କୋଉ
ନା।
ଲାଇନ ନେବ କୋଉ
ତାହେଲେ
ଲାଷ୍ଟ
ଆପଣଙ୍କୁ ଯଦି ଏ ଅର୍ଡର ନ ସୁହେଇଲା ତାହେଲେ କଣ ବାଟ ତାର?
ଯେହେତୁ କମ୍ପ୍ଲେନ ହେଇନଥିଲା ବିଫୋର ୟୁ
ଛାଡ଼, ଏଠି ବସିକିରି ମତେ କ୍ଲାସ କରିବା ପାଇଁ ଆପଣ ଚାହୁଁଛନ୍ତି। Established through such document that there has already been compliance of such order. A direction of the court in so and so. Okay, this court therefore find there is nothing survived to be adjudicated here. However, looking to the objection of Sri Misra that there is no proper compliance, petitioner if so advised may undertake appropriate exercise.
Item 23.
My lord, item 23, in this case, I pray your lordship may call this matter along with IN number 12551 of 2023.
In
12511.
221
12511.
12511 of 22, arising out of
23.
23, arising out of
Arising out of WPC number 25221.
ସେଇଟା ହିଁ ପଚାରୁଛି। ଖାଲି ଆଇଏ କହିଦେଲେ କଣ ହବ?
ଆଜ୍ଞା।
Place this matter day after tomorrow along with IA 12511 of 23 filed in WPC
26 proceeding. 26 proceeding. In the midst of hearing, my lord, he is filing contempt after contempt.
Okay, ଆପଣ ଟାଇମ ମାଗୁଛନ୍ତି ସେଥିରେ।
My lord.
ଠିକ ଅଛି।
My lord, I may pardon my lord, one thing, my lord, just I have already, my lord, the applicant applied for 2016 and already 20 rooms are completed, 17 is allotted.
Call next matter.
Item 24.
24 টা first contempt.
First contempt.
Non-compliance of your lordship's order. Item 24.
24 ରେ ଅଛନ୍ତି ଆପଣ? ଏଟା ଫାଷ୍ଟ କଣ୍ଟେମ୍ପ୍ଟ ରେ ଟାଇମ ଦିଆ ହେଲା ଆଉ 1.5 ମାସ।
And issue notice. Issue notice. Issue notice.
କଣ?
Issue notice. Why not complete?
ନାଇଁ ନାଇଁ ନୋଟିସ କରି କିଛି ଲାଭ ନାହିଁ। 1.5 ମାସ ଭିତରେ ନ କଲେ ଆପଣ ଆସିବେ ସେକେଣ୍ଡ କଣ୍ଟେମ୍ପ୍ଟ ରେ ଆମେ ତାଙ୍କୁ ଡକେଇବେ।
Item 25.
May I please, my lord? This is second contempt, my lord. The lordship has last occasion, your lordship has directed to comply on the basis of the submission made by my learned
Second
brother.
contempt, then I am issuing notice.
No, your lordship kindly see development. Now, in the meantime, my lord, draft deed already sent to the sub collector for send it to collector for the execution.
Then you don't press this for the timing.
At the
Let us
time when
see
I
the
will not press,
development.
if I will agree with this matter, I may be given
So
the
you will
liberty to
withdraw.
I will withdraw this.
Okay, further is
Because on 7/8 I filed the contempt
progress
application.
shown by the petitioner, by the counsel for the contenders through their letter number 4294 dated 9/8/2023. The Pandal and counsel appearing for the petitioner doesn't want to press the contempt application for the time being, which is dropped accordingly. However, with liberty, if any. Yes.
Item 26.
26 time first contempt.
26.
ସେଟା 26 ଟା ବୋଧେ ଅନ୍ୟ କୋର୍ଟକୁ ଯିବ।
ଅନ୍ୟ କୋର୍ଟ ପଠେଇଦିଅ। I am not, since I am not hearing this stuff. Yes.
Item 27.
27 ଟା withdraw କରିଦିଅ in view of the memo ହେଲା। Dismiss as withdrawn in view of the memo.
And appearing for opposite parties.
Yes.
I'm appearing on the.
Yes, yes.
Item 28.
Yes, any objection to impletion of party?
My lord, lordship, see the last operative portion of the impugned order, that page 54.
While disposing of the
You are
revision,
for the opposite party.
I am for the opposite party.
Who has filed this application for
My lord, I have
intervention?
filed the
Mr.
application.
Mishra.
My lord, I am for the petitioner.
Intervention at the instance of petitioner?
Intervention application keep.
Oh, aji intervention ago
ନା ଆଜି ଆଜ୍ଞା ସରିଯିବ because in view
ନାଇଁ ମୁଁ ସରିଯିବ ସବୁ ମ୍ୟାଟର ସାରିଦେବି ଆଜ୍ଞା ବସିଲେ
ନାଇଁ,
ସେ କଥା ନୁହେଁ
ଏଇଟାରେ ମୁଁ
ପ୍ଲିଜ
petition-
ଡୋଣ୍ଟ ଟ୍ରାବଲ ମି ହିୟର
ନାଇଁ ନାଇଁ କିଛି ନାହିଁ
ଆପଣ ସମସ୍ତଙ୍କର
petitioner
intention
ଅଛି,
ରହୁଛି ଆଜ୍ଞା ସରିଯିବ ଆରେ
ଏଇଟା ସରିଯିବ
section ପଳେଇଲେ ବହୁତ କେସ୍
ଏଇଟା ଗୋଟେ ଖାଲି ମତେ ଲିବର୍ଟି ଦେଇଦେଇ କ୍ଲୋଜ କରିଦେବେ।
ଆଜ୍ଞା ସେଇ କଥା କହୁଛି
ଲିବର୍ଟି
ସିଏ
ଦେଇଦେଇ କ୍ଲୋଜ
କହୁନାହାନ୍ତି
କରିଦେବେ।
ଆପଣ କାହିଁ କହୁଛନ୍ତି ଆପଣ ଅପୋଜିଟ ପାର୍ଟି ନା କଣ୍ଟେଷ୍ଟ ଲାଗୁଛି
ନାଇଁ
କଣ
ନାଇଁ
liberty
ଏଟାରେ
ମାଗୁଛି?
ଏଟାରେ କଣ ହେଲା ସେ OSS ରେ ଗୋଟେ ଅର୍ଡର କରିଥିଲେ ସେଟା that has been complied by the sub collector my lord. Now I will work out my remedy in appropriate
Petitioner
forum
wants
that
to
with that
withdraw-
observation.
Okay, all right. Petitioner wants to withdraw the writ application in order to working out the direction involved herein through appropriate mode and forum.
ଆଜ୍ଞା
With this liberty, the petition stands.
ସେଇଥିପାଇଁ ମୁଁ କହୁଥିଲି ସେଟା ଦେଖି
Item 29.
Yes,
Item
29.
number 29,
Who has
all the
filed this?
petitions were disposed of.
You have filed impletion of party
Yes, my lord. In a dispose of writ petition.
in a dispose. ତାହେଲେ ତାଙ୍କ ନାଁ କାହିଁ ଯୋଉଟା dispose ରେ ଆପଣ ପାର୍ଟି ନଥିଲେ?
In the dispose of writ application, I have filed an application to.
In the disposed of writ petition, were you the petitioner? In the disposed of writ petition, were you the petitioner?
Yes.
So petitioner in a disposed petition files a petition to implead some party.
Assistant settlement officer as one of the parties. Because after disposal of the writ petition, I have, as per the direction, I have submitted the order before the my lord, settlement officer.
So he is not working out.
He is not working out because the division bench of this court has held that the assistant settlement officer will call.
Then the order gone innocuous. Then the writ petition order is gone innocuous. You bring a fresh writ petition. Can't be implemented.
No. In the writ petition, in the disposal writ petition, I have filed the application to implement assistant settlement officer as one of the
That
parties.
I understand.
And
the application comes today. Question is if it is a disposed writ or not.
Dispose of writ.
In the involvement of some parties or not.
Yes.
Right. Now party you want to see was not a party in the disposal writ petition.
No.
Therefore the order, either that order will be recalled and the matter will be reheard.
Yes.
Or you may bring a writ application indicating all these things, sir, I have not made the appropriate party. The order has gone innocuous. So I may be granted further relief.
No, only prayer that
Have you brought application to recall that?
to modify, my lord.
Huh?
To modify.
To modify file କରିଛନ୍ତି?
ସେଇଟାରେ
Okay, finding practical difficulty in the implementation of the final outcome in the disposal of WPC 2154/9 of 23, particularly in absence of the parties ought to be added presently. This court, in consideration of both the miscases, is inclined to recall the final order dated 13/7/23. Matter stand revives. Counsel for the petitioner is permitted to bring in the press party as opposite party number 6. Matter may be placed for fresh admission day after tomorrow or Thursday.
consolidated cost title ଟା ଦେଇ ଦଉଛି.
Yes, consolidated cost title filed here. Second case, same issue?
Same.
All right, second case. Dita akre ଦଉଛନ୍ତି fresh cost title la. Yes, matter got revised. Both the matters got revised. So now it will be heard in the presence of appropriate opposite party.
Item 30.
Yes, all right, it will be corrected. Necessary correction will be made. Yes.
For addition, item 31.
Mr. Mahanti, এটা reminder আসছে
My lord, item 30.
Correction habo କହିଲି ନା typographical error correction habo ସେପଟରେ ଶୁଭୁନି କି ମିଷ୍ଟର ବୋସ୍ ଶୁଭୁନି ଆଉ କଣ ହେଇଛି ମୁଁ ବୁଝି ପାରୁନି
ସେ ଫଲୋ କରି ପାରୁନାହାନ୍ତି।
ହଁ ଆଉ ଏଗୁଡାକ ସିମ୍ପଲ ମ୍ୟାଟର ଆମେ ଭୁଲ କରିଛୁ ଆମେ କରେକ୍ସନ କରିବୁ ଆପଣ କଣ ଶୁଣିବି ସେଥିରେ
Obliged.
ଏଟା କଣ ରିମାଣ୍ଡିଂ ଆସିଛି କି
ରିଟ୍ appeal allow ହେଇକି ରିମାଣ୍ଡ ହେଇକି ଆସିଛି।
okay then some other judge will hear
ସେ in the meantime
this court no is not inclined to hear this matter in second occasion Hello. Let there be a decision by some other judge matter stand released yes ଆଉ କିଏ ଜଜ୍ ବସନ୍ତୁ ସେ କଣ ଭ୍ୟୁ ନେବେ କଣ କରିବେ ସେଟା ଚିନ୍ତା କରିବେ
opposite parties had gone there.
ଛାଡନ୍ତୁ ମୋ view I am to retain my view so why should I sit over again
Yes, yes.
Item 32.
32, your lordship may not like to hear.
32 will go to some other bench okay as this court is not hearing such counsel yes. Rest it to take permission and release it before some other bench
Item number 33 has been heard at length once before.
I am the opposite party. I have just spoken to the petitioner. I have spoken to the petitioner. I make a suggestion to your lordships. There seems to be something wrong in the sense in payment of disbursal of the amount. As I find from record, though the counter is not clear. So I'd suggested, subject to your lordship's acceptance, that the matter may go back to the board, who may decide according to the decision taken by the board. And what they are saying that the board decision has not been properly complied. So let the matter be with.
Let me have an observation that
Yes.
it appears prima facie.
Yes,
there is no
sir.
Proper
Sir, it
decision.
prima facie appears that the
Board
amount.
decision is annexure.
No, I'll just point it out.
Just 1 minute.
with my learned
Board
senior's
decision is
permission.
annexure. 1 minute, Mr. Ponda.
No.
Board
annex-
decision is
no,
annexure.
Trustee's decision.
Board
Trustee's decision.
Trustee
annexure
decision annexure.
10, page 33.
Page 33, sir.
Now your lordship will come to
Page 36.
page 33.
33.
Now your lordship will come to page 34, last para. Page 34, last para. Next para. Resolution, which is gain the approval of the board. May I read that out? The proposal for release of an amount of rupees 7108,891.46 in favor of Samal Builders Private Limited.
Mr. Panda, I will say, Mr. Padi has realized this.
Yes.
Therefore, he will take care of there. So
No.
I will just say.
So, no, lordship may.
Prima facie it appears.
Lordship may say, instead of putting me, that prima facie it appears that the decision is not
in
correct.
terms,
Not in terms of board settlement.
Okay.
Board has accepted 71 lakhs, but however, this
Therefore,
lesser
this is
amount.
set aside.
Set
this is
aside
set
and
aside.
the matter be
remitted for-
remitted back and decided within a month and the amount be disbursed, if any, within 1 month. 1 month or one.
There is
two words in that last sentence.
71 lakhs, yes.
Is approved
Yes.
towards full and final settlement. 2 words.
No, this is resolution
This
item
is the
number
trustee
4.
board's resolution.
Yes.
Trustee.
Trust board.
Item number 4.
Yes.
I get part of it.
Part of item number 4.
Last part. Last
one.
Yeah.
Resolution
So
number
resolution
87.
87 by 2018-12.
Refer to that. Lordship refer to
Is
that.
there any amount paid on this head?
Now, these amount have been paid. What has happened? I'll tell you, Lordship, the confusion. Not that I subscribe to that confusion. What has happened, my lord? A committee decided that an amount of 71 lakhs be paid.
This is the amount.
This is the amount. But after the committee decided 71 lakhs, a amount of 26 lakhs odd, which had been withheld from the security deposit, was released by the chairman after the committee's decision, not before. But then when this was decided, they have again deducted that 26 lakhs.
Okay.
So these amounts
So that has nothing to do with this.
this should not have been deducted. That's his case, and that your lordship may not be there. They don't appreciate fairness from the council. Your lordships would approve. Lordship, it may be a part of your lordship's direction.
Only confusion is,
Yes.
I bow down to what my learned
Where
senior
is
said.
your ground in the REIT application? There is illegal deduction of these 26
Yes.
crores?
Yes. Your lordship can kindly turn to page 13.
Page?
Page 12B, my lords.
Yes.
29. The very meaning and concept of security deposit is the amount deducted from the RA bills of the contract.
1 minute, Mr. Ponda, are you reading para 24?
No, page 12B, para 29.
12B.
Milord, your lordship will remember there was an amendment application as 12.
Yes, 12B,
B,
that the
para
very
20.
meaning.
Concept of security deposit is the amount deducted from the RA bills of the contractor towards the same and is to be returned to the contractor after completion of the work.
So therefore, that should not have been adjusted.
Yes.
That's
Now,
what
next,
is, that's what is.
the lordship is wanting
Yes,
to know from
your lordship understood.
ଆପଣମାନେ preparing question.
No, lordship
I am to deliver ultimately.
Yes.
ଆପଣ ମତେ
Therefore, my
ପଚାରିଲେ
order should not be confusing.
ଆପଣ ମତେ ପଚାରିଲେ କୋଉଠି ଲେଖିଛନ୍ତି ଦେଖାନ୍ତୁ ମୁଁ ଦେଖ-
ନିହାତି ଦରକାର
ସେଇଟା ଦେଖଉଛି.
That is the clarity I want.
Yes.
Party has already submitted that.
Yes, sir.
But
Yeah,
I
I'm
am to
deeply
put my
grateful
words
to you.
Yes,
here.
in the ground. No, that's what I found
I am
out.
grateful to my learned
No,
senior.
grateful.
Milord.
Okay, all right,
Yes,
both
okay.
sides take your seat. Both sides take your seat. At the submission of Sri K.B. Panda, and counsel appearing for the petitioner, as well as Sri S.K. Padhi, senior advocate, assisted by A. Das.
Shubham Sharma. S. Sharma, my lords.
Huh?
Yes, sir.
S. Sharma.
S. Sharma. Okay. Appearing for OP number 1 to 6, petitioner. Petition involved the following direction. The Ponda and its counsel appearing for the petitioner taking to the pleadings and the allegation involving the writ application. Taking this court to the resolution of the board through resolution number 87 by 2011-12 contended the benefit accrued through resolution number 87 by 2011-12 87 by 2011-12 in fact has nothing to do with the release of the security amount in favor of the petitioner. It is in the process Mr. Ponda alleged while submitting that the security amount has been returned to the petitioner as a natural course on complete completion of the work involved, and the benefit accrued through resolution number 87 by 2011-12 is an independent benefit, is a benefit independent of security deposit, and as an outcome of the contract amount, the contract involved therein. The party, then its senior counsel, however, has no dispute to the fact that there has been not only release of the security amount of rupees 26 crores.
20 exact amount of koi doche.
2537379.
2537479.
379. 2537379.
2537479.
The 4 turn with 3. The last time. 4 turn.
Set with 379.
Sir.
Okay.
253747.
379.
479.
Okay. Let's.
Oh, 100 town difference.
479.
Hela 379.
Maybe it like that.
And it has in fact it should not have been in fact a component in the outcome in the resolution 87 by 20.
Should not have been deducted. That's what your lordship is saying. Should not have been deducted from the.
Okay, that should not have been deducted from the amount determined through resolution number so and so. Considering the, however, submits. Sorry, okay, well, not disputing, submits the, okay, attempt to support the stand of the management here. This court, considering the rival contentions of the parties, fine. There can't be any dispute with the release of the security amount of rupees so and so jota rakidela 2537. For the reason there has been complete working out of the contract and release of this amount is a natural process. It is considering the dispute involved herein on the deduction of the security amount from the component decided under the heading resolution number 87 by 2011 by -12. This court find, looking to the grounds in para 26, para 29, this court observed there has been illegal deduction of the adjustment of this amount in the working out of the resolution number 87 by 2011-12.
Dated 28/12. Dated 28/12/2011.
Dated
28/12/2011.
in the resolution dated 28 कर दो 28/12 करो 28/12/11 पहला number so and so. Okay, it is in the process for there is आपको ताले 26 ଛାଡ଼ିକିରି ବାକି ଟଙ୍କା ଦେଇ ଦେଇଛନ୍ତି
ବାକି ଟଙ୍କା ସେମାନେ ଲେଖି ଦେଇଛନ୍ତି
or there is no dispute in the release of the balance amount. This court finding there is illegal deduction of sum of rupees this 25,37,379 direct the এটা কাহাକୁ trust to direct Port trust
opposite parties are
which of OP3
sir
opposite party number PPT chairman opposite party number 1 and 2
1 and 2 sir
1 and 2
sir
to
disburse the same
release
the same
the amount to the tune of the security release by working it out at least within a period of 3 weeks of the date of communication of order.
that has been worked out.
Balance. 3 weeks ago.
Oh, balance amount.
Balance amount has been worked out.
sir
ये जो additional amount है that will be released within 3 weeks. Tension the road
Great. The Lordship, can we make it just for 4 weeks if possible? Instead of 3 weeks, if possible, 4 weeks.
4 weeks.
4 weeks. 4 weeks.
Preferably within 4 weeks.
Sir, grateful. Grateful, sir.
Urgent copy.
Yes, yes.
Both sides.
Item 34.
How hearing nahi? How possible hobani?
34 ମାଇଲର ତମେ additional rejoinder
କରିବେ?
ନାଇଁ additional rejoinder ଟା ଦେଇଛି ଗୋଟେ
additional rejoinder filed in court be kept on record matter.
ଅଛି ସେଥିରେ
matter stand released. ହେଲା to be placed in its original serial in its own serial term kar
ମାଇଲର ଏଟା ନିହାତି urgent matter ମାଇଲର ଏଟା
ସବୁ urgent
ନା ଏନଓସି ଟା ନିହାତି ଏଟା ଆଉଟଲେଟ ଦବା ପାଇଁ
35
item 37 ଟା personal
ଆସୁଛି 35 also delisted
discrimination ହେଇଛି ମାଇଲର ଏଟା ଟିକେ
ନେଇ ପାରିବେନି ଆଜ୍ଞା matter କିଛି
next week
also delisted
item number
next
35
week ମାଇଲର ହଉ
yes 37 only
I'm so sorry. Item number
37 only delisted all these matters wherever in
37 Miller
to continue
pursuant to your directions Miller sub-collector is present. Your Lordship last time directed sub-collector to show further development and intimate the petitioner. We have already intimated.
Is satisfied?
No, they have six months time, under 6 months time to
ठीक है
comply.
मिस्टर दास छाड़ी दियो तक माइक
My lords, in item 35,
I can't take up any final matter, small matter.
No, my lord, I don't want to argue finally, my lords. Can I just?
Therefore, if you, madam, listen, you are struggling for last so many years, months, maybe. So therefore, I grant you liberty. If you find urgency, you move Chief Justice to assign it to some other bench. I can't take up any final hearing now.
No, my lords, I was not saying that. If my lords will just permit me one sentence, my lords, I was saying there's an unintended consequence of the interim order that was passed.
Sorry, I can't get into my merits. I grant you liberty if you are so interested.
Please, my lords, will.
Listener since pressing hard. Counsel for the opposite party, no? Counsel,
Yes, my lord, I'm
jury is counsel for opinion.
Yes, but in this case,
Yes,
your lordship had observed in the very first order.
Oh, Sadam to see.
No, ଗୋଟେ ଖାଲି କହିଦେଉଛି କ'ଣ ଖାଲି
Oh, forget that.
ଆଜ୍ଞା ନା ଆପଣ କହିଥିଲେ ଯେ despite the interim order
Miss Johri is pressing hard for final outcome in the matter. Okay, this court find time constraint in getting into final hearings. Therefore, while releasing the matter, observes in the event, the grants liberty to Ms. Johri to move Honorable Chief Justice for placing this matter before any other bench. Interim order to continue.
File your measure. Hello.
37 ରେ ଆମେ further development ଟା show କରୁଛୁ plus ତା ଦେହରେ prayer କରୁଛୁ ଆମକୁ ଆଉ 6 ମାସ time ଦରକାର।
ସେ କଣ satisfy ନୁହେଁ ବୋଲି
On 15th 11th.
order କଣ ହେଇଥିଲା ଦେଖିଦବା।
To dispose of repentation.
Dispose of
Not
repentation.
dispose, to take a decision, disposal, decision.
Decision on the repentation.
Decision regarding annexure 8, annexure 8 that to give me the
Yes,
position
decision on the repentation at annexure 8.
Yes.
Now what do you say? There is constraint, time constraint.
Time constraint.
ନା କଣ କିଛି proceeding କୋଉଠି କଣ pending ଅଛି?
ନାଇଁ ବର୍ତ୍ତମାନ ଚାଲିଛି proceeding ଚାଲିଛି ବର୍ତ୍ତମାନ rainy season ଯୋଗୁ ଆମେ eviction କରିପାରୁନୁ।
Repentation disposal eviction କଣ?
The last time your lordship directed for to show further development and intimate the petitioner the development below.
All right, all
On-
right.
on
All right,
15,
filing.
on 15/11/2020.
But
in that
speaking order is
format of-
already there.
My lord?
Speaking order already there.
Yes, yes,
ତାହେଲେ read order comply ହେଇଯାଇଛି।
yes. Only 6 weeks time to eviction the
So in the
encroach.
disposal of the repentation, you have taken decision to clear the land.
Yes,
That is taking time.
time.
Yeah, that was not the direction of the High Court. So therefore contempt will no more lie.
My lord,
ଟିକେ ମାଇକ୍ ଆଗରେ ରୁହନ୍ତୁ।
my lord, on
Read ରେ କଣ direction ହେଇଥିଲା?
to take a decision of annexure 8. Annexure 8 is my
So take a decision. They have taken decision.
decision.
They are working it out.
Yes.
ନା ଆପଣ କହିବେ ତାଙ୍କୁ ଜେଲକୁ ପଠେଇ ଦିଅ। What
No,
is
no,
this?
I will-
ଆଉ ତାହେଲେ ବସନ୍ତୁ
Uh,
ବସନ୍ତୁ। ଦେଖ read petition was disposed with the following direction. Quote କର
ମୋର ତ further ଯେମିତି ଆଉ
Court
retribution କରିବା ପାଇଁ ପଡିବନି ସେଇଟା ଟିକେ ଦେଖିବେ।
ହେଲା। Yes. In the issuing of notice in the content proceeding, the Sri Panda appearing learned AG Havani, counsel appearing for the contemptor bringing the speaking order to the notice of the court submits there is already final order on the repentation of the petitioner in a way favoring the petitioner. Direction therein being worked out is taking some time. Taking some time. For there is already giving out a lawful order on the repentation at annexure 8, this court find contempt no more lie.
My lord, again, I would have to file another writ for restoration of
ଆସିବେ
possession.
ଆଉ 20 ଦିନ ଗଲେ ମୋ ଘରକୁ ଆସିବେ ପରାମର୍ଶ ଫି ନେଇକି କହିବି ଆପଣ କଣ କରିବେ।
ସେଟା ଆପଣଙ୍କ ଟାଇମ ରେ ଏଟା ଶେଷ ହେଇଯିବ ବୋଲି ଭାବିଥିଲି କିନ୍ତୁ 5ଟା
ଉଠିବା।
5ଟା
ହିୟରିଂ ପାଇଁ କଣ
ନେକ୍ସଟ
ହେଇଗଲେ ଦିଟା
କଭର ଆଜ୍ଞା ନେକ୍ସଟ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଓକିଲ ମୁଁ କହିଲି ସେ କହିଲେ ଯେ